Today will be smooth and still.
approval.
Motion to approve.
I'll second.
And a second. Any discussion of those? Hearing none, then all in favor indicate by saying aye.
Aye. Aye.
Opposed, same sign. Proceedings stand approved. Report from the Executive Director's Office, Mr. Randall.
Thank you, Chairman Compton. Bob Randall for the department. So I am going to touch on just a couple of things, primarily having to do with money this time around, because we've been doing a lot of talking and thinking about that at the department and at the administration. First, I will just note, I think this is the first meeting since the legislature adjourned in early May. Did I have that right? I can't remember the last time, but
I think they've adjourned. I'm not positive.
They have. They've gone home, I believe, and the department made it through this legislative session with our agenda intact, and we're proud of that. It was a good session for DNR. One piece that was included in the long bill this year was an extra appropriation for the Oil and Gas Commission, and that was a $3 million appropriation of severance tax Tier 1 money to go to the Oil and Gas Commission to make up for, and Matt might talk about this as well, or he might not, the decline in mill levy revenue coming in the door for the OGCC. And so we worked with the Governor's Office, OSPB, and with the Joint Budget Committee staff. They understand and appreciate everything that the Commission does, and felt that it was important to see the operations unimpacted by the mill levy declines. So anyway, we were really happy about that, and we think that that's a good plan for going forward, at least in the next year. So that was sort of mid-session, and then in the final weeks of the session, the state Supreme Court issued a decision, the BP America Production Company versus the Department of Revenue. And I'm going to spend a few minutes talking about that because I want to be sure that the Commission understands that case, understands the ramifications of that case, and I'm happy to take any questions on it. So if I go a little long, please just give me a high sign and I'll stop. But I'm, again, happy to take any questions on it. So
I will check with counsel.
Okay. Yeah, feel free to kick me under the table. So, and this audience, I have a feeling, understands this case better than most of the audiences to whom I've made this little presentation. So anyway, I just want to be sure you guys understand the case. So this was a case that was interpreting the allowable deductions from a taxpayer, in this case an oil and gas operator's severance tax liability. The statute is very broad. It says that an oil and gas operator can deduct any transportation, manufacturing, and processing costs against their severance tax liability. This was litigation in which BP challenged their ability to deduct the cost of capital associated with their investments in transportation infrastructure. So basically they contended, and this was back, the case was initiated in 2008, it challenged tax returns filed in 2003 and 2004. So this is all sort of old news. But they asserted that they should be able to deduct the return on investment that they would otherwise obtain from the money that they were investing in transportation infrastructure. So again, cost of capital. The Department of Revenue had denied those costs, arguing that return on investment from pipeline investments is not a deductible transportation cost. It's not a direct cost, but it's rather a hypothetical cost or an opportunity cost. So that's what Revenue argued. And again, BP argued the opposite. And the court, the Colorado Supreme Court ultimately sided with BP. And that was a case issued, a decision issued on April 25th, with just 2 weeks left in the legislative session. And so we were all sort of struggling and scrambling to understand the effect of that decision, both looking backwards and looking forward. So I'm going to talk about those quickly. So the effect of the decision at its most general will result in refunds being issued to BP, the litigant in this case, and other oil and gas operators, and also reduced severance tax income going forward. And I'll walk through each of those. So first I'll look forward. So the Department of Revenue is still trying to figure out how many operators have been claiming these return on investment deductions and other deductions that might be allowable under the Supreme Court's decision. They're trying to figure out how many operators are already claiming some of those deductions. And again, I know a lot about how to spend severance tax. I don't know a whole lot about how it's collected. So this is all in revenues court. They believe that operators can also claim against their severance tax liability what are called NERF deductions. These are deductions listed on their net back expense report forms that is claimed on their local property tax forms. And those are also just associated with oil and gas field development. And so revenue believes that we're looking at reduced severance tax income going forward as a result of companies claiming these deductions in the future of between 12.5 and 15, maybe 20%. I recognize that that's quite a swing, but they really don't know the scale of deductions that have been claimed to date. They believe that some companies are already claiming these deductions, but they'll be working through that. In testimony to the Joint Budget Committee, the Friday before the session ended, Revenue presented facts where they believe that past tax returns will result in about a $25 million refund liability. Those are tax returns that have been filed, that have been denied by Revenue and contested by the taxpayer. And so those are firm numbers, that $1 million liability looking backward. They believe that there's up to $75 to $100 million of future refund liability due to oil and gas operators being able to amend their current tax year return, the 2015 return, and then the 3 previous years. That's the statute of limitations. Next, 90 days, more or less, they will be seeing amended returns coming in the door that will result in a pretty significant severance tax liability for the state, because we have to pay these returns because these are now deductions allowable. The Supreme Court decision. So the Joint Budget Committee heard all of this. Again, this is on the Friday before the Wednesday that the session ended. They discussed it and ended up voting unanimously to propose legislation that ultimately became law. So I can tell you the punchline there, that will have those refunds paid out of the general fund reserve. So rather than being applied against future severance tax revenue, which would essentially zero out frame over the next year or more, they voted to pay these out of the general fund reserve. They said this is a fund set aside, this is a rainy day fund, this is an unanticipated very large cost that would have big impacts, and so they are going to pay those out of the reserve. At the same time, they placed restrictions on unobligated severance tax money that the Department of Natural Resources has and the Department of Local Affairs has. So for every dollar that comes in the door from severance tax, DNR gets 50 cents, Department of Local Affairs gets 50 cents. Ours is then split another in half between the perpetual base account that funds water infrastructure projects and other things, and the operational account, Tier 1 and Tier 2, which you guys might have heard. So this legislation that JBC proposed and ultimately passed, it's Senate Bill 218, places a $10 million restriction on unobligated funds in the operational account that DNR maintains, a $19 million restriction from the perpetual base account, and a $48 million restriction from DOLA's local government severance tax fund. That money hasn't been swept, it's still there, it's just got a hold on it, so we can't spend it, but I think that they felt like that was the responsible thing to do in the event that refund liability was greater than they thought it was going to be, or in the event that the general fund didn't grow at the rate they projected, and it would be hard on the general fund. So we have a hearing before the Joint Budget Committee later this month on either the 20th or the 21st, at which they'll discuss this, and we'll probably get an update from Revenue as to what refunds they've seen and things like that. So we'll know more as the summer wears on. For DNR is that out of the operational account, Tier 1 programs, including the funding that I mentioned, is going to the COGCC, along with other programs that fund staff and important work at the Department of Natural Resources. Tier 1 programs will be kept whole. Those will be, we anticipate there being sufficient revenue in the next fiscal year to keep those funded at the level we've anticipated on forecasts. It looks like Tier 2 will not get any money in the next year. Tier 2 includes a lot of programs that DNR doesn't administer. The Low-Income Energy Assistance Program being a large one, grants that go to the State Forest Service, some programs within DNR like the Water Supply Reserve Account that funds the Basin Roundtables and provides money for them, aquatic nuisance species mitigation at state parks, state wildlife areas, and other state water bodies. That won't get any funding. We'll have to find money from elsewhere for that. So that's significant. We've got, we're working on contingency plans to make sure that those programs, don't suffer entirely. Some of those funds have a reserve or they have money in them that we can continue to do work. The Species Conservation Trust Fund being another one that you guys might have known about. So that's what it means. I guess that's what we're looking at as far as how to repay the liability that results from all of these refunds. What we think it means for operators claiming these deductions going forward, again, is about a 15 to 20% reduction in funds going forward. So all of the projections that the OSPB economists make are being called into question. And over the course of the summer, we really do think that we'll have a better. It was a little shocking to us that this case didn't get more attention in the media until there was legislation that arose out of it. I think a lot of people were trying to figure out what it means, and I just wanted you guys to understand at least what we understood at this point. So I know I just threw a lot at you, and I'm happy to take questions now or over the course of the day.
Commissioner Hawk?
I just have questions I was thinking about. Do we know, and this is just more out of curiosity, if our state law is in line with other states on the same issue, or are we unique in this respect, or do we know?
My sense from looking at this in the past is that it's a little bit, each state does it a little differently as far as severance tax goes. In Colorado, there are a number of provisions that are unique to Colorado. This, I believe, being one of them, though honestly I haven't looked at other states and their ability to deduct cost of capital or lost return on investment costs. Colorado is one of the few states that has the ad valorem offset that allows operators to deduct a portion of their state or of their local property taxes against their severance tax liability already. You can look at effective tax rates across states, and they're all affected by these deductions. Some states are higher, most states are a little higher than Colorado's, but as a practical matter, I think it's difficult to compare them directly.
And I just wanted to clarify, funding for the Oil and Gas Commission staff is going to continue to be maintained. There's no hold or reduction in that we're aware of.
No, not at this point.
I'm jumping into.
Well, no, again, a lot of this is based on projections, but based on what we know today, the funding that goes to the Oil and Gas Commission that funds staff and things like that out of Tier 1 of severance tax will be won't be impacted by the decision.
Okay.
Other questions? Ms. Murphy, I noticed that Commissioner Holton is in his chair.
He has joined us. Unfortunately, Commissioner Walk still is absent, but I'm sure he'll show up soon.
Okay, no other questions? Oh.
If I could, I had one other thing and that is just, so I don't know how to lead into this. I know that I just wanted to say that I know today we are going to do a fair amount of acknowledging and celebrating the service of 3 of our commissioners for whom this is their last meeting. And that is Chairman Compton, Commissioner Allward, and Commissioner Craig, who's on the telephone. And it's so good to hear your voice, Commissioner Craig. And maybe I just want to be the first to say, and it's going to be said a lot today, but thank you so much for your service to the commission. For me, it has been a treat because I've been associated with the commission in some capacity or another since shortly after you all were appointed. And through the 2008 rulemaking, I was with you through that and all of the time we got to spend together in various venues during that summer. And really, your service has been exemplary and longstanding, and for that I thank you. They call some of us who work for the state public servants, but I just want to acknowledge that the service you guys give is selfless and you're volunteers, and I just really appreciate it. It's been a pleasure to work with you and to get to know each of you. So thank you.
Thank you very much. Commissioner Allward, do you want to comment or you want to leave it up to me?
I'll let you comment, even though you're shocked now.
I'm going to offer a rebuttal. You can, I suppose.
We have to vote.
It has been an absolute pleasure to work for the Oil and Gas Commission staff and to be chewed out in public by the likes of, but I won't mention any names, but the exceptional group of attorneys that come before us and the folks, citizens of Colorado. It has been an absolute pleasure. I've really enjoyed 98.5%. Commissioner Craig, did you have a comment?
It's just been my honor and privilege, and I've enjoyed the last 8 years.
Very well. Report from the director. I believe that would be you, Mr. LeBoer.
Thank you, Mr. Chairman. Maybe I should check with the Assistant AG to see how much time I have.
Well, let's see how much time you take.
All right, I'll do my best. All right, not necessarily in order of importance, but you don't want to miss this one. The July hearing, scheduled for the 19th, sorry, I've already thrown us off, the 18th, 19th, and 20th, 3 days, you're wondering why. And it's in Glenwood Springs, not Sterling. So I'm going to say that again. July hearing is in Glenwood Springs, Colorado, and we're going to schedule it for 3 days. Day one will be an orientation because, as you now know, if you didn't before, we are in the midst of a significant transition on the commission with 3 long-serving members, this being their very last hearing, and hopefully we will have 3 new commissioners in place. If we don't have those 3 new commissioners in place, the hearing matters will take place on Monday and Tuesday as they normally do. If the 3 have been named, we will have an orientation session with them on the 18th, and we will conduct the hearing on the 19th and 20th. On May 2nd, the Colorado Supreme Court handed down decisions in 2 cases that affect us rather directly. Those were the cases of Longmont, a fracking ban, a ban on hydraulic fracturing and disposal of hydraulic fracturing-related fluids within the city limits of Longmont, and in Fort Collins, a 5-year moratorium on similar activities within the city limit. The Supreme Court held in both cases that those ordinances were preempted by the Commission's rules and regulations relating to hydraulic fracturing and waste disposal. The decision was short and simple and direct and straightforward. I think it was 8 pages in total. The highlights are that the court said it was applying well-established rules of preemption. It decided the case on grounds of operational conflict, not implied or expressed preemption, so that was noteworthy that the court held that our regulations do not impliedly preempt all local regulations. Rather, the local regulations are valid if they can be put into effect without operational conflict with our rules. Here, that was not the case. The regulation of oil and gas is a matter of mixed state and local concern. That's what leads us to the operational conflict analysis. And then the other interesting thing the court said was that in virtually all cases of operational conflict, the analysis will be, one, a facial analysis of the language of the statutes and rules, in play, rather than an as-applied test. So in prior operational conflict cases, sometimes lower courts had said, we need to see how this works, when you try to implement it. The plaintiffs here had argued the defendants here had made similar arguments, and the Supreme Court said, nope, we're going to look at the language, and if you can't, reconcile these two things, then there is a preemption situation. So, want to give my great thanks to Jake Matter, the Assistant AG who led this case up through the Supreme Court for the Commission. He got to argue the case in front of the Supreme Court, did a great job there, did a great job on the briefs. So sorry he's not here, but we are grateful to him for his good work there. I want to note that you might want to silence your cell phones.
That goes without saying.
But you didn't say it this time. The Interstate Oil and Gas Compact Commission, of which I am a member of the steering committee. I also chair a committee at the COGCC, the Legal and Regulatory Committee, held their annual business meeting here in Denver on May 15th, 16th, and 17th. Chairman Compton gave the opening address to that body, a lively and entertaining history of oil and gas in Colorado and developments in oil and gas along the Front Range, and what it means to be a long-time rancher and mineral owner in Colorado. So it was a fun opening address, very well received. We had great participation by some of our teams, some of our managers and staff. Really a very nice, successful program for IOGCC. We had about 200 attendees, despite the slow economic situation. So we were pleased with that. For the staff, Jane Stanzik presented to the Legal and Regulatory Committee on our idle well bonding program and what we've been doing to raise the amount of money that we hold on idle wells, monitoring that closely, again, in sort of this economic environment where if an operator has a lot of shut-in wells, we start to get a little bit nervous. And we do have Rule 707 allows us to raise the bond amount or collect on those shut-in wells. Todd Hartman, Public Information Officer for DNR, also presented. He presented in the Public Outreach Committee talking about kind of our crisis communication during the 2013 floods. And then Mike Leonard, our quality assurance professional, otherwise known as the single greatest oil and gas inspector in the country, was a co-coordinator of a field inspector forum that was held in conjunction with that. Just a couple of quick notes on statistics. Maybe if I can find those notes. I know we've talked that production in 2015 set another record, which would seem counterintuitive, but here now is kind of the flip side of the coin. Right now, drilling permits at an annualized rate are down about 30% from the past 5 years or so. Annualized, we would see about 2,800 permits submitted compared to about 4,200 permits in most recent years past. Well starts are similarly down. Well starts at an annualized rate, we would only start about 732 new wells this year compared to 1,400 last year and compared to about 2,200 again in years 2012 through 2014. So activity is clearly slowing. We do not imagine that production can continue to, increase year over year as it had. We don't expect it will match the 2015 numbers. I'll use that as a segue to talk just a little bit about money. About 70-ish% of the COGCC operating budget comes from a mill levy tax on the value of production. So The production value is two factors, how much of it and what it's worth. And we all know that what it's worth is down substantially over the last couple of years, and now we've been propped up a little bit by that growing production. As that starts to tapers off, we're going to see less revenue coming into the COGCC. So Bob touched on the severance tax, the one-time infusion of severance tax that the legislature provided this year. That will serve us well for fiscal year 2016-2017, which starts here July 1st. After that, if our projections are accurate, and that's a notable if. I mean, they are projections. They are projections based on historic production, based on the number of well starts. We try to take into account a lot of factors, but predicting the price is a little dicier. So, based on projections, without changing anything else, we aren't counting on this tax for 17-18. We can't count on that. We would enter 2017, 2018 with really not enough money in the account to keep operating through the next fiscal year. So the option that is available is to raise the mill levy rate. The mill levy rate has been at 0.07 since 2007. So a lot of credit goes to Wendy Schultz and Bill Levine, and so the financial people who have managed that mill levy rate for many years. But we're not going to be able to just manage our way through it if things don't change substantially. So the statute, the Oil and Gas Conservation Act, allows us to tax that production at a mill levy rate of up to 1.7. So we have room to move. That is a tax that does have Tabor implications. We have to be mindful of those. So a lot of moving parts. With all of that said, it is safe to say that unless there is a substantial change in the next 6-ish or so months, we need to be thinking about or actually taking steps towards a mill levy increase. We do that by rulemaking. And, you know, based on current projections, we would say that mill levy increase is somewhere between 0.2, I guess it is, or hundredths, I don't know, but from 0.7 to maybe somewhere between 0.9 and 1.3. We'll just have to see what happens. It is very fluid. We will continue to monitor it. We will have conversations with the regulated community. I'm sure they will want to have discussions with others about other sources of revenue, including the severance tax. But as Bob has indicated, there are constraints on that as well. So, stay tuned. And with that, I would like to turn to say thank you to the outgoing commissioners. As Bob teed up for us, this is a significant transition. The 3 outgoing commissioners, first of all, you're all doctors, so I'm going to call you Dr. Allward and Dr. Compton and Dr. Craig today. All of you have served. Dr. Craig has served 8 years. Drs. Compton and Allward have put in 9 years of service to this commission. Any of the rest of you in the audience or listening who have been around know that those have been not the easiest 9 years in the commission's history, probably, and maybe with some degree of increasing intensity over the last 4 or 5. So I just want to take a second. Again, Dr. Craig, so happy that you're with us this morning. You know, what I have learned from you, Dr. Craig, over these years is always state the problem. Identify the problem. What are we trying to solve? It's amazing to me how often we have to remind ourselves of that and stop in our tracks and go back to the beginning and say, what is the problem? You've also taught us that it is not a good idea if you are an operator to fall short of your expectations when it comes to conducting oil and gas. And I also have to say that you have inspired all of us with your strength of character and spirit over the last several months. So thank you. We have a pump jack here for you. It has your name on it, and we will get it into your hands in the near future.
Thoroughly sterilized.
Yes. Yeah.
Dr. Craig, you have the floor.
I just want to say thank you. Like I say, sometimes it got to be a little bit difficult, but usually those are the most worthwhile challenges. I wish I could be with you today, but you're all aware of why I cannot be. And I've really enjoyed my time with the commission. Hopefully I've had an impact.
Undoubted. Dr. Allward, I think about you. I think about your commitment, demonstrated most memorably by your participation via video conference from, I think it was Australia, it was the other side of the world, for 3 days of rulemaking via video conference, during which you were staying up all night to be able to participate. Not that the hearing itself ever got boring, but when it did, we would just look at you and your struggle to stay awake, and that inspired us all. You have often found yourself, I think, swimming somewhat against the tide of majority opinion on this commission. That is not always a comfortable place to be, and you have always done it gracefully and with diligence and with respect, and I admire that very much. So thank you for your 9 years of service. Shall I hand these out? All right, there you go. You have a package to open.
Spoil the surprise.
Sure. Dr. Compton, I think that all I have learned from you over these several years is everything important about life. You unfailingly conduct yourself and these hearings with grace and humility, as you did this morning, with respect for everyone who appears before us, and I have to say, with the patience of Job. You have been a sounding board for me, professionally and personally, for which I am grateful, and you have guided us, this commission, through setback rules, water sampling rules, Governor's Task Force rules with great aplomb. So thank you very, very much.
Thank you.
No, thank you.
Thanks, sir.
Shall we open this?
I suspect it is expected.
It's not a model, as we used to say when we opened presents when I was a kid.
Batteries included.
Oh, we might have to charge you for those. All right, so while they open and play with their new toys, I will tell you all that we are having a reception this evening at 5 p.m. at Agave, which is 10th and Lincoln. It is open. There will be appetizers provided. You do have to buy your own beverages because this is the state. So, lady and gentlemen, thank you, thank you, thank you.
All I can say is I've looked forward to this little pump jack for 9 years. and I'm very appreciative.
I've been looking forward to this pump check for longer than that because I work with somebody who has one. So it's been something, I mean, it's the whole reason I asked to serve on the commission.
Okay, thank you so much. Any pertinent questions for the director? Hearing none. Commissioner comments? Dr. Allward.
Thank you, Dr. Compton and Chair. I would like to say a few words. One, thanks for the pump check. And
Well deserved.
this has been an extraordinary experience. I think working alongside all these Coloradans who are really working hard on behalf of the state. I've appreciated all the staff that I've had the chance to work with, the expertise they bring, the dedication in their service to Colorado. It has inspired me. I've worked with 3 directors now. I don't know how many different managers and supervisors. It speaks well of all of you that the transitions have been so smooth. Clearly, you're hiring and training and bringing up employees in the spirit of what it means to work for the state. And it's extraordinary to see the change. I've lost count of how many hearing officers I've gone through and worn out. But they're an unflappable breed. I don't know where you find them, but it doesn't seem to matter what you throw at them. Calm, collected, and keep things moving forward, and or dismiss me out of hand as when appropriate. My fellow commissioners, this is, I mean, the diverse expertise on this commission makes this commission work. I got involved with commission matters back in 2006 when I made the foolish decision to run for state office, and felt that what was important was not the people. The people were important, but we didn't need to change them. We had great people on the commission. We continue to have great people serving on the commission, but the mission that guided us and our adherence to it is so important. And I've really appreciated the changes and then how we work together. We're passionate in our differences. As the director brought up, we defend what we're passionate about quite vocally. But our votes tend to be almost unanimous, if not unanimous. And that's in part because we have a similar goal, the service to the people of Colorado. And thus we listen to each other and seek compromise so that we can make that unanimous vote. And the attorneys that have been before us have been really impressive. If I would have known the good work that attorneys can do when I was a college student, I might have considered law, but probably not. So it's been a great time, and probably the most fun is when my wife can say that she saw me perform live at the Paramount Theater during the 2008 rulemaking is a highlight of my service. Thank you all. Thank you.
Thank you, Rich. Thank you, Director Lepore, for allowing me to attend the Interstate Oil and Gas Compact Commission. That was very, very enlightening for me. And one of the reasons was I got to see firsthand, I've heard, I don't know how many times Director Lepore has told me that the state of Colorado has the absolute best set of regulations of anywhere in the world, you understand. And I, of course, just kind of dismissed that as Director Lepore, you know, he's in a position where he sort of has to say that. But having attended that meeting, I think I can honestly say, and I am convinced that, in fact, that's a true statement. And listening and talking to many of those folks from around the United States, Colorado does, in fact, have about as good a set of regulations as you could have in place to meet the mission that Rich referred to. And I'm certain as well that the reason for that is primarily the excellent professional staff that I'm going to say we have put together here. Obviously, Director Lepore, formerly Director Neslin, had a huge part to play in all that. But our staff is really, really good at what they do, and they do it very professionally. And it has made my job, and I'm going to assume our job corporately, a lot easier to have that kind of expertise. We have irritated them from time to time. I do recall a time or two when we've had some discussions. We didn't have full agreement, but they have always been very professional. And it makes, again, our job just a lot easier. But I really am, and I'll reiterate what Rich said about the commissioners. In our time on this commission, if there's one thing that stands out, is the professionalism of the commissioners. They always come to these hearings fully prepared. I never have to worry about someone being here, unless it's me, not being fully prepared, knowing exactly what the issues are, and being, above all, open-minded to hear what's being presented and to give their very best analysis of it. So thank you all, commissioners and commissioners in the past that may not be here. The three people that are coming on, if I do say so myself, in all humility, have big shoes to fill. So thank you very much, and thank all of you. Okay, next item on the agenda. Wait a minute. Are there other commissioner comments? Tommy, you're not crying, are you? I know he's not. Okay, other commissioner comments? Hearing none. Audience comments, Ms. Murphy.
Chairman, we have two people signed up. Dave Devaney to discuss URSA applications, and then also Mr. Neslin.
Okay, Mr. Delaney?
Devaney.
Delaney.
Devaney.
Devaney. I'm going to come up to the microphone, Mr. Devaney.
And Mr. Devaney, before you actually start talking, are you planning on talking about anything that's on the agenda today, or is it something separate?
I believe it's separate.
And then is it anything that's pending in front of the commission or the commission staff or the division?
I don't know. These are issues that are certainly, appropriate at this body, whether they're on the.
Well, I'm just trying to make sure it's not something that needs to be on the record for a specific matter, so that it's not ex parte communications.
I don't think so.
Okay.
I don't think it's a problem. Correct me if I'm wrong.
Well, what we'll do, I think, Counselor, if it's okay, we'll listen to Mr. Devaney's comments. If in fact they impact a future hearing item, then I'm not sure exactly professionally or legally what we need to do. But you can certainly listen to the comments and see what you have to say.
So if it sounds like it's going to impact some decision in the future that the commission's going to hear, we might end up cutting you off and bringing you back during that specific matter. But we'll let you know.
Okay. Well, I hope I didn't drive 100 miles for nothing, 200 miles for nothing. But anyway, good morning, commissioners. My name is Dave Devaney. I live in Battlement Mesa, Colorado. I'm the co-chair of the citizens group Battlement Concerned Citizens. I made the trip here today to talk to you about the pending applications to drill for natural gas inside the residential community of Battlement Mesa. which, by the way, those applications are the first to be considered under the new regulations for our urban mitigation areas. It is my understanding that the operator, URSA Operating Company, is anxious to get your approval for the application for 2 well pads, 52 wells, an injection well, and other associated pipelines and equipment necessary for that type of application. Well, the residents of Belmont Mesa are anxious too. We are anxious about an injection well near our drinking water supply and right next to the Colorado River. We are anxious about the negative impacts of an industrial operation, oil and gas development near our homes, schools, churches, that will be part of our landscape for the next 30 plus years. And this is just phase 1. We are anxious because the CDPHE has concerns about the location of those well pads and the likelihood of an injection well so close to our drinking water supply. We are also anxious because this operator, URSA Operating Company, has demonstrated that they cannot abide by the current regulations that are supposed to protect our residents from odors. We are currently surrounded by other URSA projects in our community and feel those impacts on a regular basis. Numerous failed inspections and notices of alleged violation have resulted. We are anxious because we have been subjected to terrible odor problems due to bad management practices that have resulted in NOAVs and financial penalties.
Mr. Devaney, are those the items that are on the agenda for today that you're referencing?
No, I'm talking about the other ones that are not on today's agenda. Those BMPs have caused one impacted family to make the difficult choice to leave Belmont Mesa, try to sell their home in a depressed real estate market, and find employment in another state. And all these events have occurred before the drilling inside our community has begun. We are anxious because the operator, URSA, despite self-promoting claims of greatness, have the reputation in Garfield County of running an operation on the cheap. This does not bode well for our residents that may be relying on URSA to use the latest cutting-edge technology and practices to reduce but not eliminate the negative impacts. We therefore request that the COGCC staff take all the time necessary and due diligence required to ensure that the Colorado residents of Belmont Mesa do not become collateral damage. I was also going to request that you consider moving a future COGCC meeting to the Western Slope, perhaps in October, but you scheduled in July, close enough. So I thank you for that. And I want to add my personal thanks to the outgoing commissioners, Commissioner Craig and Commissioner Compton, and particularly my West Slope compatriot, Commissioner Alward, for your many years of service. So I would be happy to answer any questions that you may have.
Thank you very much, Mr. Devaney. We appreciate it, and I can reasonably, I think, assure you that this commission staff will take all the time they need to analyze any hearing application that may likely come before this commission. Thank you.
I have one other question. Another resident of Belmont Mesa had planned to make the trip here today, the family that I had talked about that have to move. And they sent me they were planning to be here, but due to potential job interview situations in other state could not make the trip, but emailed me a written message this morning, and I'm wondering if I might be able to relate that to you in their absence.
I think I'm going to say probably this isn't the best forum for that. I would expect you help me if you would, that at the time that a hearing takes place where this URSA application is being considered, would be appropriate time for that email, as well as for what you have stated here in a, what they call a 510 statement, I guess, to be delivered to the commission and commission staff. Thank you very much.
I understand. Thank you.
Okay, Ms. Murphy, you said there was also
Mr. Neslin?
Mr. Neslin. Mr. Neslin. Oh, this Mr. Neslin.
Yep.
I believe we've met.
I've had the pleasure. My name is Dave Neslin, and I just want to add my 2 cents to the statements that have been made by Director Lepore and Director Randall and others of appreciation for you, Chairman Compton, and you, Commissioner Allward, and you, Commissioner Craig. I've got a little different perspective. I had a chance to work with you all as part of the staff, and I've had a chance to appear before you as an attorney, sometimes successfully, sometimes not so successfully. And I think everybody in the state, and particularly those of us who enjoy its quality of life, consume energy, owe you all a tremendous debt of gratitude. You've handled major rulemakings every year and a half or every 2 years. Throughout your tenure, you are addressing hundreds of adjudicatory applications each year. You've dealt with a never-ending parade of new issues, and along the way, really, you've made the state a leader in responsible energy development and in tackling very difficult issues involved in regulating this kind of development as it moves into new areas and uses new technologies and proceeds in different ways. And you've done it all with grace and good humor. As several of you have noted, you've made unanimous or near unanimous decisions, but you've also shaped the issues that have come before you. And I think each of your fingerprints are all over the regulations and the policies that the state administers and that other states look to and even other countries look to as a model. Earlier this year, Peyton Manning retired. He's going to be a first ballot Hall of Famer. I just want to say you're all first ballot Hall of Famers in my book. You just don't get paid the same way. So thank you all.
Thank you, Mr. Neslin. Do you know Peyton Manning maybe put in his name for commissioner? Thank you very, very much, David. I appreciate it. Okay.
Chairman?
Miss Murphy.
I think we have a late sign-up. Mr. Simpson from URSA.
Well, I think that's appropriate. I probably stepped on your toes earlier, and I apologize for that. Not you personally, but...
No, not at all. I was hoping not have to say anything today, but I feel the need to with the earlier comments. I wouldn't say that URSA is anxious to get these permits through. We've been working on this for over a year and a half with community outreach. We've had numerous meetings with unanswered issues that people have in the community. We've gone through 6 on-sites, public on-sites, with not only the county, but the COGCC and the CDPHE. We've had gone through a lengthy county process where the Planning Commission went through over 40 hours of open comment from the public. We've addressed those issues in 53 or so BMPs that are in our permits. We've also, and that was approved by a 6-to-1 vote with the Planning Commission, and then a 3-0 vote from the county commissioners on our permits. In our BMPs, when Kirby Wynn, the oil and gas liaison of Garfield County, requested that we extend the public comment for our permits as our applications, we willingly agreed to that. We've been trying to work with the COGCC in answering all the questions. It is a complicated area for sure, and we're trying to be the best operator we can. It's we want to do it right, and we trust the COGCC is dotting the I's and crossing the T's just as the county did.
Thank you very much. Rich, am I wrong? Was it like first field trip we took when we got on the commission was Battle Mesa was a part of it.
Was a part of it, yes.
So it's been on our radar for some time. Okay. Ms. Murphy, if it's okay with you,
Yes, Chairman.
even though I'm way behind schedule, I'm going to go ahead and take a short break, 10-minute break, and then we'll get into the consent agenda.
At your pleasure.
Oh, at your pleasure.
Yes, sir.
Okay, short break, 10 minutes. agenda. Ms. Murphy, you have any, we'll take items, we'll consider items A through R.
Yeah, I would want to double check that there aren't any recusals.
Let's just check and see if there are any, what's that word?
Recusal.
Any apparent conflicts that you want to confess? Okay, hearing none, seeing none, I think we're okay. You've had the consent agenda in your hands for several days now, so what's your pleasure?
Mr. Chair, I move approval of groups A through R on the consent agenda.
We have a motion for approval A through R.
I have a question.
Well, would you give me a second, then I'll go ahead and move for questions.
Okay.
That's okay.
I'll second.
Okay, good. So you don't put him in a compromising position. So we have a motion and a second. Discussion.
All right. I was just going through these different groups, and I saw a couple of cases where I just had a question about the spacing. And this is in Group G, and it's docket 1606002226, where it says there's 3 approximate 480-acre horizontal wellbore spacing units that are in for pooling. And the only thing that was confusing to me is I didn't see but one 480-acre description of lands, so I didn't know if there's 3 overlaying spacing units in that case.
Yes, that's correct. There are 3 overlaying horizontal wellbore spacing units.
All right, so there'd be like 2 different spacing units in the Niobrara then?
I believe. Yeah. If we have the applicant's attorney here, and he can probably speak.
Well, I just wanted to get some clarification. I couldn't really.
Is it okay, Ms. Murphy, if we get the attorney that actually wrote this up to answer these questions?
Thank you.
Yeah, I could give a short explanation of what's going on here. Greg Nybert with Davis, Graham and Stubbs, attorney for PDC Energy Inc., the applicant in this matter. So, as Julie said before, we have essentially 3 overlaying wellbore spacing units, 2 to the Niobrara and 1 to the Codell Formation, and so that's why the legal description is the same for all 3.
So is there 2 different productive intervals then that'll be developed in the Niobrara separately?
Yes, so I believe in these 3 spacing units, you have 2 wells in the Niobrara which are at least 150 feet away from each other, but include, based on the 460-foot designation that you have to have within Rule 318A, they just happen to have the same legal description for the wellbore spacing unit.
So 150 feet apart vertically, we're talking about?
Probably laterally, actually.
Oh, I see what
Yeah.
you mean. So you've got,
Yeah.
but so you have a separate spacing unit for each
Yes.
individual well then?
Yes.
All right. And then it looks like that's the same case on the next docket at 1606000227. There's a 2 400-acre wellbore spacing units, but only 1 description. So I'm assuming that's the same.
Yes, that's the same case for docket 227.
Okay. All right. Thank you.
All right. Thank you.
Thank you, Mr. Nybert. Any other items of discussion? We have a motion and a second for approval of the consent agenda items A through R. All those in favor indicate by saying aye. Aye. Opposed, same sign. Consent agenda is approved. Okay, the enforcement group A. So can we do both of those or need to be separate? A and B? Okay, we'll do A and B together. Any
Mr. Chair,
Commissioner Allward.
I'll need to recuse myself from B, so we should just.
Okay,
do
and
them
we'll just do A. Do them separate. Enforcement Group A. What's your pleasure?
Motion to approve.
We have a motion to approve
Second?
and a second. Any discussion? All those in favor indicate by saying aye.
Aye.
Opposed, same sign. Enforcement Group A stands approved. Note that Commissioner Allward is recused from Group B.
Right.
Any action you wish to take?
Motion to approve.
Move to approve.
Second.
And a second. Any discussion? Hearing none. Those in favor indicate by saying aye.
Aye. Aye.
Opposed, same sign. Group B stands approved. Enforcement hearings. Docket 1603000081.
Thank you. Good morning, Commissioners. David Beckstrom, Enforcement Officer with the COGCC. Give me just a second. I'll pull up the presentation. Come on. F5, all right. Couldn't get to the bottom of the screen now. All right. Commissioner Craig, are you able to see that okay?
Commissioner Craig, are you able to view this from?
I'm just on the phone. I'm unless it's already a package in the portfolio, I'm not able to see it.
It is.
There it is.
So,
the package was in the portfolio.
Okay, I got it.
all right. Again, David Beckstrom, Enforcement Officer with the COGCC. Today, staff brings docket number 1603000081, requesting the Commission's approval of an order for closing the financial assurance of Cliff J. Nolte, LLC. Cliff J. Nolte, LLC, for all intents and purposes, has ceased operations as an oil and gas operator in the state of Colorado. Mr. Nolte was the sole owner, employee, manager of the company. He passed away in December 2015. Prior to his death, his daughter and the personal representative of his estate contacted the COGCC to inform us that he had developed severe dementia prior to his death, and in light of those circumstances, requested the release of the $60,000 financial assurance held by the COGCC. Upon receiving that request, staff conducted a review of all of Nolte's holdings in the state and determined that the only remaining operation for which Cliff J. Nolte, LLC remained responsible for was the Cottonwood Grazing 122 location in Lincoln County. The Cottonwood 122 location has only one well on it. It's the Cottonwood Grazing 122 well, and it was first spud in January 2011, drilled to total depth in February 2011, and was declared a dry hole and never produced. Some reclamation work was done in 2011-2012 at the location. Reclamation staff, upon receiving the request for release of the financial assurance, went and did an inspection in August 2015 and again in March 2016. At both inspections, reclamation staff noted that there was the presence of weeds as well as a lack of desirable vegetative cover at the 122 location, and therefore failed it for final reclamation. Currently, that site has just been left with a barbed wire fence around it. As you can see, there are weeds on location, and a transect was conducted of the site to determine that desirable species were not present in the amount required by Rule 1004. In light of the circumstances surrounding Cliff J. Nolte LLC and its lack of active operations, staff now requests that the Commission approve the proposed order that can be found at page 6 of your portfolio. This order requests foreclosure of the financial assurance of $60,000. That's $20,000 cash and a $40,000 CD that's held by MidFirst Bank. We also request authorization for staff to apply those foreclosed funds to conduct the necessary reclamation work at the location. We request authority to revoke Cliff J. Nolte LLC's authority to continue operations in the state of Colorado. And finally, we request authorization to refund any unused portion of the financial assurance back to Cliff J. Nolte LLC at the completion of the reclamation work and the passing of the location for final reclamation. Ms. Jana Marzano, as the personal representative of the estate of Cliff J. Nolte, was provided a copy of this proposed order, and she has stated that she does not oppose its approval. Therefore, unless there are any additional questions, staff now requests that the Commission approve the proposed order as set forth at page 6 of your portfolio, foreclosing the financial assurance of $60,000 of Cliff J. Nolte LLC.
Thank you, Mr. Beckstrom. Any questions? Okay, hearing none, then what's your pleasure on the staff request?
Motion to approve.
Mr. Chairman, I recommend that we approve staff request.
Okay, we have a motion to approve from Commissioner Craig and a second from Commissioner Holt. Any further discussion? Hearing none. Those in favor indicate by saying aye. Aye. Opposed, same sign. Stands approved. Thank you, gentlemen.
Thank you, Commissioners.
Next item. Docket 160100080, CM Production LLC, Logan and Washington Counties. Mr. Farron. We're ready, sir.
Good morning, Commissioners. Jeremy Farron, Enforcement Officer at the Commission. I'm here to present staff's case in 1601E, which is an enforcement action against CM Production LLC. I'm here to present some of the materials that are already in the record. We submitted everything in writing in order to decrease the hearing time associated with this hearing. We've also decided not to call any witnesses. All their testimony has been submitted by affidavit. But John Axelson, East Environmental Supervisor, is here to answer any questions I can answer as well. So,
Ms. Craig, are you able to hear Mr. Farron?
Yes, I am.
Thank you.
So the first question you may have is, why is CM before the Commission again so soon? You'll recall the Commission heard a substantial case against CM in March. What you weren't aware of was that there was an outstanding NOAV that had been issued against CM, and we postponed the hearing on that NOAV, waiting to see what was going to happen in March. So you entered your order in March. It gave CM a little breathing room, and we again postponed the hearing on the outstanding NOAV, waiting to see what sort of progress would be made. And Commissioners, the reason we are here again so soon is that there was no progress. So the order you entered had deadlines. CM failed to comply with those deadlines. I've been with the Commission a little over 2 years now. And during that time, we've worked very diligently to work with CM in order to return them to compliance, and they have not been able to. And so, in staff's opinion, it's time we stopped giving CM second chances. So before you today are 3 questions. The first is that outstanding NOAV, which alleges a violation of Order 507. We're also asking for you to find a pattern of violation for CM's failure to comply with 3 recent enforcement orders. And then we're asking that you approve staff's proposed order, which, among other things, will revoke CM's right to conduct oil and gas operations in Colorado. Starting with the pending NOAV, Order 18507 was an AOC. It was agreed to by CM and it was approved by the Commission in May of 2015. It imposed a penalty, and a portion of that penalty was suspended pending successful future compliance. Here's an overview map. The matter you heard in March related to locations on sort of the western half of the state. You can see the Lone Pine and Margaret Spalding locations. Order 507 dealt with 2 properties on the eastern side of the state. You see the Rice Well and the Warren Well there. So 507 specifically related to land treatment of oily waste at the Warren Wells, and then some erosion control work at the Rice Well, among other things. Staff has alleged that CM has violated 507 4 different ways, and I'm going to go through each of those here. The first is by failing to actively treat the oily waste at the Warren location. And in this context, active treatment of oily waste requires regular working of the soil, possible addition of amendments, but really some active working of the soil. Otherwise, you're not going to have successful bioremediation of the soil. If you just take oily waste and put it in a pile, it's going to still be oily waste years from now, and it's not going to reach our cleanup standards. So again, we're talking about the Warren Wells here. Through a couple selected photos from exhibits 6 and 9 showing some of the waste areas at the Warren Wells. I've circled a darkish material here in a picture taken in September of 2015, and it supports our contention that this area has not been regularly worked, because in a follow-up photo taken in May of 2016, you'll see the same materials. It hasn't been incorporated, hasn't been spread. It's just sitting there as a clumpy pile of oily waste. And staff would expect something different. They would expect this soil to have been worked in and no longer visible based on a photo. Here's another waste area at the Warren Wells. Again, picture taken in September 2015. It just looks like the materials have been placed there and then not regularly worked. Here's a follow-up photo that shows, again, clumpy soil. Doesn't look like it's been worked. Looks like it's been weathered as the rain comes down on it, but it hasn't been actively treated. So that's the first violation of 507. The second violation is a little easier. CM was obligated to file semi-annual progress reports. And those progress reports are important because that's what staff needs to see in order to see whether or not the treatment of the oily waste is progressing and leading towards a cleanup standard. And most importantly, those progress reports are also supposed to be they're also supposed to come in with laboratory analysis of the oily waste so that staff knows that the levels of the oily waste, that they are decreasing over time and that we're going to reach cleanup standards in a reasonable amount of time. So CM was obligated under the order to file 3 different progress reports, April 2015, October 2015, and April 2016, and CM failed to file all 3 reports. The third violation of 507 was CM was obligated to install some erosion control work at the Rice Well, and here we are at the Rice Well, and then here's an aerial of the Rice Well. The rice well has 3 produced water pits. I've labeled the north pit and the south pit here because they are the 2 we're concerned about because they are located near this ephemeral stream that you can see on the right-hand side. The erosion control work was meant to sort of buttress up the east wall, right? Yes, east wall of these 2 pits and keep the sediment from sloughing off down into this ephemeral stream. So here's an overview. Picture taken in August of 2015. You can see that's the pit wall, one of these pits. There's no erosion control work been installed here. The due date for that was May of 2015, so this photo was taken after. And then here's a follow-up from this year. Same thing, no erosion control work has been installed. Here's a picture from the pit wall of the north pit. This shows it a little bit more clearly, the erosion coming off of this pit wall. Again, photo taken in August of 2015 and follow-up photo looking the opposite direction, but this is the same pit wall taken in May of 2016. And I should note that those were select photos from exhibits 10 and 11. The last way in which CM failed to comply with 507 was by failing to pay a $15,000 suspended penalty associated with Order 507. In November of 2015, after CM had missed 2 progress reports and after we had conducted inspections of both locations, we issued the pending NOAV. We also sent this letter which demanded payment of the $15,000 that had previously been suspended, awaiting successful completion of the compliance requirements. We sent this letter. There was a deadline for payment of the suspended penalty, and CM failed to pay. So moving to a penalty calculation, violation of an enforcement order is a Class 3. It's our most serious classification. Staff has determined that a moderate impact has and is still occurring based on this noncompliance, and we counted 227 days of violation. When you plug that into the formulas, you come out with a penalty of $359,650. The next question, and perhaps more important, is staff's request asking that you find that CM has engaged in a pattern violation. And rather than dwell on all of the individual rules, I could have tallied them all up, but I thought it would just be easier to concentrate on CM's failure to comply with 3 recent enforcement orders. The first is 507, which we just discussed. The second is 412 and 413. Those 2 orders were the subject of the March hearing. You'll recall 412 set forth some compliance requirements at the Lone Pine Field, the Margaret Spalding location. And 413 was CM's voluntary agreement to comply with the requirements of 412. So in the order you issued in March, which is 569, you found specifically that CM had failed to comply with orders 412 and 413. So it's not something new that you need to decide here today. It's already been decided that they failed to comply with that order. So the last failure to comply with a recent enforcement order was CM's failure to comply with the order you issued in March, which is 569. And that order had a number of requirements. There's a number of requirements that are due even into the future, but these were the first 3 that came due, and CM failed to comply with all 3. The first requirement was a requirement to post $210,000 in financial assurance pursuant to 707. They failed to post that. Once we realized they had missed their deadline, we sent them a demand letter unsuspending the penalty that was associated with that, and CM failed to comply with that demand letter paying the suspended penalty. And then next, they had an option to choose either paying $150,000 penalty and remediating the Lone Pine Field by the September 1 date, or they could post a larger amount, $200,000, as a bond under 702, and then negotiate a different deadline. So the initial piece, they had to post either the 150 or the 200, and that came due in April of 2016, and they failed to comply.
Mr. Farron,
Yes, sir.
the date that appears in 3A at all problematic?
It is not, because they needed to post the 150 and then move along down the road to complying prior to September. They also have some obligations to MIT certain wells pursuant to that order too, and that deadline has not expired, but they've blown the first three, and I don't think there's any expectation they'll meet that September deadline.
Thank you.
Actually, Alex Fisher, the West Environmental Supervisor, should be here if you have specific questions about them meeting that deadline. No? Okay. So the last question before you today is whether or not to adopt staff's proposed order. And in order to sort of give you the background, as CM stands today, they owe the commission something in the neighborhood of $500,000 divided between penalties and additional financial assurance, depending on their election with that bullet point number 3 that we were just discussing. That's in addition to any penalties you would impose today for failing to comply with 507. So it's a substantial hole, but it's more than just money, it's also compliance. And like we mentioned, disposal of the oily waste at the Warren location, the erosion control measures at the Rice location, the substantial remediation required at the Lone Pine Field, the Margaret Spalding locations, which were the subject of the March hearing, and then also 5 MITs that are due and owing. And that's just compliance due pursuant to enforcement orders. That's on top of their regular obligations to comply with our requirements. So it's a substantial hole.
The MITs are past due.
They are not.
They're not. Okay.
I apologize, I don't recall the deadline. I think it's the middle of June or July. So those will come due. We're not alleging that they have failed to comply with that requirement. We're just saying it's one more thing that's on the list of things to do. So moving to staff's proposed order, which is at Bates page 181, we're asking for a finding that CM has violated Order 507, imposition of a $359,650 penalty, and then, as is typical with our orders, ordering CM to return to compliance within 30 days. We're also asking that you find that CM has engaged in a pattern of violation, which then authorizes the director to immediately suspend their Form 10. Starting with this second bullet point, we're moving into remedies that we have not sought with respect to CM thus far. Again, revoking an operator's right to conduct oil and gas operations, foreclosing their financial assurance, giving staff the authorization to go out there and do some of the work necessary to stabilize these locations. And last and most importantly, staff has lost confidence in Mr. Teff's ability to manage an oil and gas company in compliance with our requirements. So this last bullet point describes an obligation for Mr. Teff to notify the COGCC should he join or form a different company as a principal. And that's a requirement that has been imposed in a couple recent orders, but it's definitely not something we do often or take lightly. I do have one.
Excuse me, just for a moment.
Yes.
In this case, you're asking for revocation of the right to do business as opposed to a suspension of the right to do business.
Yes. I do have one slight revision to the proposed order, and this is at Bates page 190, paragraph 8, and we ask that you delete the words declares bankruptcy and /or from the proposed order. It was a confusing addition. Your order here today can't amend federal bankruptcy law, so we would just like it stricken to avoid that confusion. So I apologize for its inclusion, but if you could just delete those 4 words, that would be helpful. So to summarize again, 3 issues to address: whether they violated 507, whether or not they've engaged in a pattern of violation, and whether or not to adopt the proposed order. So unless there are any questions, we respectfully ask that you adopt the proposed order with the slight revision that I just mentioned. Thank you.
Do you intend to have some response from
Oh, yes.
CM?
Yeah.
Okay. Any questions for staff? CM response.
I don't have a prepared document or any information for you guys. I think this is completely out of control. Give you a couple of examples.
Excuse me. Go ahead and introduce yourself
I'm sorry.
for the record.
I'm John Teff. I'm the principal of CM Production.
Thank you very much.
Jeremy showed a slide up there that says that we won't negotiate with the COGCC to change to deal with the bonding or the penalties. Matt won't call back. 2 months I've been trying to get a hold of him. Multiple phone calls. I reached out to Peter to try to talk to him. Won't even meet. Won't discuss it. Specifically related to this, there's a couple items that I'd bring up. First of all, these sites are stuff that we inherited. Problems took over. They've been like this for years. The soil, when they show you those pictures up there, it's just like what Alex Fisher showed last time. Those pictures are deception. They show a little spot and say nothing's been moved. That's not accurate. That second photo, the soil is got way too much liquid in it to work it. Is the soil getting better? Yes, it is. The environmental guy's sitting right there. If you guys want to ask him questions about what's passed, what's not passed, it's progressing. They show you a stream that's running through the rice. There's no stream there. That was deemed not a sensitive area like 10 years ago. We had an environmental guy look at it. He deemed it as not a sensitive area, yet they keep bringing it up. They show pictures upstream of our field of water saying that it's leaching out of our pits into the... How does water run uphill? I want to bring up a couple of comments that have been made to me, and I probably should have talked about this last time. Matt told me in a discussion that he was going to get the money out of me before we could spend it on other places. I don't understand that kind of mentality. Basically that we're going to give the money to the Oil and Gas Commission rather than fix the problem. Mr. Axelson made a comment to me that if he was a small operator in the state of Colorado, he would not be here, inferring that he's got direction from above to run this. The Colorado Oil and Gas Commission has direction from above to run small operators like me out of business. Well, you guys are doing it. This is what's coming. We have no ability to pay these huge astronomical fines. We don't have any issues in any other states, just here. I find that kind of a pattern of showing that, operate 100 wells in other states. We can communicate with the inspectors. We don't have problems. They ask us to fix something, we fix it, we take care of it. We communicate back with them to see if it's fixed. Jeremy said that they worked with us. I don't even understand that comment. I don't really have a lot to say about it, this whole thing, other than last time I was here with the Lone Pine thing, we inherited this mess. We've tried to do our best to clean it up. The AOC was approved, or the plan was approved by the staff, and then they backed out of it, and they want to push it to a hearing. I don't really have a lot other to say about any of this. I mean, I don't think that it's in the best interest of the Oil and Gas Commission, the state of Colorado, or the people of Colorado to take these assets from us. That just doesn't make sense to me. As far as working in the state of Colorado, again, I probably would never buy another thing. I'm a native here. I would probably never buy another thing in the state of Colorado. You can't communicate with the COGC staff. I'm not the only frustrated operator. There's many small operators that are just flat irritated with this system. I'm just one that is hung up here to communicate with you guys. I don't know what else. That's probably all I got to say about any of this. I hope you guys have some questions. I hope you'll look into the details, see if the pile's really been treated. Ask our environmental guy if the tests are getting better. See the other problems that got solved. They show you a picture of the rice showing the erosion. There's erosion all through the creek system. There's no ability to grow grass or do control all through the creek system. That's just natural. That's probably all I got to say.
Okay. For the presentation,
Mr.
comes
Chairman,
your response.
if I could ask Mr. Axelson a quick question. John, have you seen any laboratory analysis specific to the Warren location, well, at all?
No, nothing's been submitted to document that any sampling or analysis has ever been completed at any of the land treatment locations.
That's all I got.
Mr. Axelson talks to the environmental guy. Why didn't he ask him? If that's missing, why doesn't he just ask him rather than put this presentation together and worry about litigating?
I really won't, I don't need any. I mean, you understood that, I think I understood there were 3 reports that were due that were not filed. That right, 3 of them? Okay. Okay, any questions? What's your pleasure?
Could I just ask one question?
You could ask 5 questions.
I'll need a couple minutes to think up some more. Mr. Teff, you've made some claims here about what's been done and what has not been done. But you brought no evidence. What is the evidence that the soil quality is changing, that you're moving forward on MITs, that we've got these reports that are not due? Do you have anything to show us that says you've done this so that we could then challenge what the staff has claimed in their documentation?
I think, no, I don't. The reports, part of the reports were submitted. I think the soil analysis was left off the last report. The environmental guy is here if you'd like to ask him direct.
If you've got this information, you should provide it to us.
As far as treating it, I know it gets treated. I've treated it once myself, but I haven't regularly treated that. Allegation that it's not being worked regularly is just not accurate. Would you like to ask the environmental guy the question about the?
No, I don't think that's necessary.
Other questions?
And I would just like to make a quick point. Although CM's not represented by counsel, the hearing officer gave them every opportunity to file stuff into the record here, and they've chosen not to file anything. So essentially, in staff's opinion, this is all undisputed.
It does, I guess from my viewpoint, you guys, it doesn't do any good to submit information because it gets taken out of context, just like those photos. So.
Okay. I'm entertaining a motion. If you can't find my body language.
Mr. Chair, I move approval of recommended order with the amended deletion of 4 words.
Before you go there, can I make a suggestion on paragraph 9? It's a little bit inconsistent with the Administrative Procedure Act. Just make a revision to the entry of this order constitutes final agency action for purposes of judicial review, effective after the date it's mailed by the Commission, instead of the 30 days, because that's not the time frame for judicial review anymore under the statute.
Yeah, we have no objection to that.
Okay, Commissioner, you sort of understood what...
I'll take that as a friendly amendment.
Okay, we have a motion. Is there a second?
Second.
And a second. Any further discussion? Commissioner.
Thank you, sir. I will just say that I'm going to support the motion, and I don't do that lightly. I do think that we have a case of undisputed facts, and I would urge Mr. Teff to to take seriously the requests for information that come from the staff, because we as commissioners are in a position to find facts and draw conclusions from them, and based on what we have in front of us, I think, again, I don't do this lightly, but I see a pattern of violation, and I'm going to support the motion.
Thank you, Commissioner Randall. Other comments?
I just want to make one comment. I agree with Director Randall that we have to take the staff's proposals and their presentations very seriously. And what I see is kind of a bad attitude from you as an operator in the state. And I think you've been given opportunity to try again. At the last hearing, we asked for some additional bonding and gave you some options that staff says you haven't pursued at all. And I'm just kind of at the end of my rope personally, on trying to cut any slack for a small operator that disregards our rules and our staff's requests. So I'm in support of the motion, and I'm sorry to see that you haven't taken the COGCC's request seriously.
Who should I talk to?
The staff.
I mean, Matt won't speak to me. I call him and he won't return calls. Ask Peter to have him contact me. Who should I talk to?
Okay, other motion, second, discussion. Those in favor indicate by saying aye. Aye. Opposed, same sign. And the staff's recommendation stands approved. Thank you.
Thank you, Commissioners.
Is there something wrong that I can't be that far ahead?
You are reading my mind.
Well, I don't know if staff would be prepared already for an 11:30 agenda item.
I suspect that staff would be. I see Mr. Eisinger in the room.
Well, let's proceed then with the 2,500-foot mandatory setback from oil and gas development study. And Chris, take all the time you need.
Before I was worried about lunch, but it's still a little bit early for that.
Before you jump in, Chris, Chairman, may I ask a question? In the event we stay ahead of schedule, we could reach out to the remaining hearing item for this afternoon and see if we could take that up perhaps around 12 or 12:30.
Yeah, that would be fine with me if that's okay with my colleagues.
I will see if they can make an appearance earlier than 1 o'clock.
Why do we always have that beautiful picture of Telluride up there in the background? I believe that's near Telluride.
Looks like it. So am I good to go ahead?
Yes, sir, you are.
Good morning, Commissioner.
I'm trying to fill air. And
my name is Chris Eisinger, and I am a senior research scientist here and also the GIS manager. What I'm going to present on today to you all is a recently introduced initiative. It's one of 4 citizen-proposed initiatives that I think Director Lepore alluded to at the last hearing that would potentially impact oil and gas development here in Colorado. The one that I'm focusing on here is initiative number 78. It proposes to amend the Colorado Constitution to establish that all new oil and gas development facilities, including those that use hydraulic fracturing, must be located at least 2,500 feet from an occupied structure or area of special concern. The commissioners at the last hearing asked the COGCC staff to assess the potential impact of this on surface access, and so that is what I've done. This is a fairly modest effort to do this. Of critical importance is the definitions for occupied structure and area of special concern. In the language in the proposed initiative, they say an occupied structure means any building or structure that requires a certificate of occupancy or building or structure intended for human occupancy, including homes, schools, and hospitals. For area of special concern, that would be public and community drinking water sources, lakes, rivers, perennial or intermittent streams, creeks, irrigation canals, riparian areas, playgrounds, permanent sports fields, amphitheaters, public parks, and public open space. So the challenge for us here was just trying to identify what data sets that are publicly available would match this language as closely as possible and be as accurate as possible. And for the occupied structure, that's a bit challenging because it's difficult to go out and actually measure every single structure and certainly know whether it's occupied or not. And so after discussions with a couple other GIS professionals and doing some research, we learned that the GIS address point data that's collected by counties and municipalities is probably going to be the most practical and reasonably accurate data set to use for this assessment. And so that is what we used. Some counties have great data sets, others are incomplete or out of date. The state GIS office has compiled a statewide data set that is fairly good from 2014. There are about 13 counties, I think, that are missing. Most of those counties are not centers of oil and gas development. These address points are typically structures, and they are typically occupied. There are some cases where they're vacant parcels, but that percentage of the overall is quite low. The accuracy of those points is very good. In 2003, there was a study that looked at it, the accuracy, and it found that the median distance between a GPS point, meaning someone went out in the field with an instrument and said, where is this structure, versus what the GIS point was less than 125 feet. We can assume that that only has gotten better. I spoke with a gentleman who's the GIS director at Weld County, and he said that they've spent a lot of time going out in support of emergency services. They need these address points to be as accurate as possible for the structure itself. So I think it is, like I said, accuracy is good. As I mentioned, there are 13 counties that had no data. The Weld County data that was used was 2016, and all the others were from 2014.
Well, Chris, in reference to the 13 counties lacking any data, so they're not included in your analysis?
That's correct, yeah. They're just left for this portion of these occupied structures. Yeah. And
can I just add, I had that question when I was looking at the study, and so when we were looking at the entire state, you're taking the surface area of the entire state, including those 13 counties, but you're not subtracting any of that as something that would not be, or that would have been impacted by the proposed ballot.
That is correct. Okay. And I will say there is a caveat that I'll explain in just a sec why it's not that far off. Okay. And that's when we start to include the areas of special concern. So here's just an example of that in Weld County. All those yellow dots represent the structures, address points, and as you can see, they generally lie within fairly close proximity of what looks like a structure, most of, again, which should be occupied. So that is for the occupied structure data set. For the area of special concern, this, of course, includes a lot of different features that they identify. For this, we have just included lakes, rivers, perennial intermittent streams, creeks, and riparian areas, so hydrography data. I looked at getting the things like open space, public parks. Unfortunately, those don't exist at an aggregate level. Like I could go to a single city and probably find some of that, but to try to aggregate it up to a county or even statewide level would be very time-consuming. and probably not necessary for this because most of those are going to be within fairly close proximity to occupied structures. So we use the USGS National Hydrography Dataset, the NHD, and also the U.S. Fish and Wildlife Service National Wetlands Inventory. And specifically, the NHD, for anyone who's familiar with this, it is a very impressive data set. It's been around since 1988. It includes just about all surface water feature classes. And we wanted to, of course, limit this to exactly what was the language that was in the proposed initiative. And so that meant using the features specifically for stream, rivers, canal, ditches, lake, pond, and river. And I purposely excluded things like ephemeral streams, which would increase the extent. So, and the NHD, it's a digital vector data set. Like I said, they started in 1988 at a fairly large scale for the whole nation. And in the last 15 years, they've done everything at a high resolution at 1 to 24,000 scale. I questioned the accuracy of some of this stuff in the NHD, but apparently there is a tremendous amount of field checking that goes into it, and they require that 90% of the features lie within 40 feet of the true geographic position. So I think it's a reasonable data set to use for this sort of assessment. This is the map for the whole state that shows those hydrographic features. As you can see, it's pretty overwhelming. There aren't many places in the state that don't have some sort of one of these hydrographic features within probably 2,500 feet. And this shows at a much finer level, again in Weld County, just what that merged data set looks like, with those purple circles representing active wells. So for the analysis, very simple. This was just using GIS to create 2,500-foot buffers, setbacks, and so this is those red or the yellow squares represent those occupied structures address points, and when you add a 2,500 buffer, this is what you would get, how those merge together and overlap. For that same area, we can add the hydrographic features and add a 2,500-foot setback for that, and then combining the two, you can see we start to cover a large area of this particular view. Statewide, and this is all in a report, by the way, that was prepared and put out a week and a half ago, which I think most of you have seen. So statewide, we see that for the occupied structures alone, you see about 22% of the total surface acreage. Here's where you're correct. That's going to be overestimated. It'll be less than that, just because of those areas that I've left out. And those counties we don't have the data for are the ones in the orange-red color there. But here's the more compelling impact, and that's from these areas of special concern, again, just from the hydrography. And this is for the whole state, and that's 89% of the total surface of the state. You get to about 90%, again, because there's a lot of overlap between those two. Just two counties, the top two producers, Weld County, because of the higher population density, you are going to see a significant impact, over 40%, just from the setback associated with occupied structures. And for graphic features, areas of special concern, in this case, it's 80%. And combining the two, you end up with 85% of the county. For Garfield County on the western slope, this is where the hydrography is perhaps more impactful. You can see we're approaching 99% of the county. It would be the same in La Plata and some of the others where you just have a lot of drainages that have been identified. So in summary, it's fairly straightforward. You're going to see a huge impact, 95% of the total surface area for the top 5 producing oil and gas counties. The setbacks associated with those areas of special concern, again, think hydrography, surface water features, that's a much more significant impact. And in populated counties such as Weld and others along the Front Range, any setback from occupied structures is going to be much more substantial. So with that, I will answer any questions you may have.
Questions?
Thoughts? And I started to look at the potential if you were to try to access mineral rights from an area that was allowed based on this proposed initiative, to say what's the maximum distance you would have to go laterally. And I'm still working on that just as a curiosity to see what that would be. But I think in some cases you'd be drilling miles and miles and miles to get to certain mineral rights.
Well, thank you very much,
Just real quick.
Commissioner Allwood.
Thank you for doing this analysis, and I think it's, well, for one thing, it highlights the amount of waterways that you'd never guess were there when you're hiking around in western Colorado and just desperate to find something that looks moist, not to mention wet. But I guess all those changes in topography are waterways. And I really appreciate the effort that was taken to make the language and the findings and the conclusions very specific to what was found. That this is one analysis, and I think it was always undertaken and understood to be very specific to one way of looking at the what the direct language of the initiative would result in, and I appreciate the way that the report now concludes about those findings.
Amen. It's very interesting. I'm going to be interested in seeing an analysis from proponents of this ballot initiative, a similar analysis, to see what other GIS experts might come up with. It seems difficult to argue against this. I'm sure someone can make a good argument. Any other comments or questions?
I just really appreciate the enlightenment. I try to envision just, from my experience, what would a 2,500-foot setback look like? And I think it's pretty easy to envision from homes what the impacts might be. But the impacts from all the areas of special concern are definitely way more than what you would envision. So I appreciate your enlightenment on this.
Sure.
In all candor, Chris, when I read your report initially, I talked to the director and I said, this is no way, this can't be. There's got to be a mistake. Just didn't make sense. I looked out, stood on the back porch of my ranch house and said, come on now. But after I reread it and considered it, it was overwhelming to me.
Yeah, and again, it's because water is everywhere in the state, even though it looks like it isn't.
What's that word? Ephemeral?
Ephemeral, yeah.
Ooh.
Well, I just want to share my thanks to Chris for your hard work on this and in responding to the request from the commissioners. It's a great piece of work and very well documented and balanced. So thank you for your work on that. Yep.
Other comments or questions?
Speaks for itself.
I remember when we did some setback rulemaking, agricultural had some real concerns about the setbacks we were proposing at that time and how it would impact their ability to be able to continue their agricultural practices. This would certainly have something to do there as well. Thank you again. Any other comments, questions? Excellent work. We appreciate it. Okay, Murphy. I'm sorry, Ms. Murphy.
Wasn't TC. No, Chairman. I understand that Adam and staff will be ready around 12:30. Lunches will be here about 11:30. And, we could perhaps do some improv, but I think that'd be painful for everyone. So I would suggest regrouping, 12:15 or 12:30.
What should we do in the meantime?
I don't think I'm the right person to answer that question.
Okay. And we'll anticipate reconvening at 12:30. Okay, so we are in recess, I guess. reconvene. And I believe the item before us is docket 16040000073, Adam Petroleum. And is that right?
Adam, yeah.
Okay. So, unless Ms. Murphy tells me otherwise, you're in charge.
That's frightening. That really is. Thank you, Mr. Chairman, Commissioners. This matter is set for an order finding violation hearing before the Commission. Multiple violations were alleged against Adam. The parties have agreed to liability and penalties for violations of Rules 308A, 308B, 309, 319B, 326C, 210D, 605A, 804, 906A, and 907. They've also agreed on the $149,469 in total penalty and the methods of calculating those violations, the required corrective actions, and the consequences for Adam's failure to perform the corrective actions. Ms. Beckstead will explain the details, and then the Commission will need to approve this agreement at this hearing. The undisputed issues and stipulated facts attached to staff's pre-hearing statement dated May 24, 2016 as attachments 2 and 3 were adopted by the hearing officer and are in effect binding factual findings. The remaining disputed issues are, first, whether the operation of the pumping unit at the Taylor 3 well was a violation of Cease and Desist Order 1C-10, and whether staff's requested $90,000 penalty for this violation is appropriate. Both parties will have 60 minutes each for their presentation, including its opening and closing arguments, case-in-chief, rebuttal, and cross-examination. Time spent in answering Commissioner questions will not be charged to the parties' allotted time. The case presentation will be as follows. A determination first whether any Commission members have a conflict of interest. Any preliminary matters, including staff's presentation of the undisputed issues, and this time will not be counted as part of staff's presentation time. So when they're explaining the settlement they've reached, that doesn't count towards their 60 minutes. We'll have opening statements by staff and then by Adam, presentation by staff, presentation by Adam, rebuttal by staff, and any rebuttal by Adam. Then Commissioner questions, closing statements by staff, closing statement by Adam, and the closing of the record. You will then need to make findings and rulings regarding approval of the undisputed violations, penalties, required corrective actions, and consequences for non-compliance as set forth in Attachment 2 to staff's pre-hearing statement and as explained by Ms. Beckstead. You make a finding regarding whether Adam violated the cease and desist order by operating the pumping unit at the Taylor 3 well, and if you find that they did, you'll make a finding regarding whether staff's requested $90,000 penalty for violation of the cease and desist order is appropriate. And with that, Mr. Chairman, you're now in charge.
Who's the timekeeper? No words. And the Counselor, I don't think I have any kind of conflict. I certainly have no financial interest in any of this. I have had some discussions with neighbors in the vicinity reaching out to me to suggest I wasn't doing my job. Things were happening that I'm supposed to, but I don't think that's it. Well, Ms. Bex, that's nice to see you.
Good to see you too, Chairman.
We're at your disposal.
Oh, great. Well, good afternoon, Commissioners. Britta Beckstead, Assistant Attorney General and Counsel for Commission staff in this enforcement action. Thank you, Enrique. On February 11th of this year, staff issued an NOAB to Adam Petroleum, LLC, which I will refer to as Adam, for violations of this Commission's environmental and site maintenance requirements at the Taylor 3 well. On February 23rd, due to Adam's failure to respond to the Commission's request for corrective actions on these violations, as well as the unauthorized operations at other wells, the Director issued a cease and desist order that encompassed the Taylor 3 well and these other wells. Adam then violated that cease and desist order by continuing to operate the pumping unit at the Taylor 3 well. On March 23rd, staff issued a second NOAV to Adam for the failure to comply with the commission order. This NOAV is combined with the prior NOAV in this enforcement action. This enforcement action includes both undisputed issues, as Mr. Rouse explained, and disputed issues regarding the second NOAV for the violation of the cease and desist order. For the undisputed issues, the parties have reached agreement on 10 violations of commission rules, their associated penalties, and corrective actions. The signed agreement between the parties is in your portfolios at Bates pages 14 to 21. This agreement is also incorporated into staff's proposed OFE at Bates pages 30 to 38 and was also handed out to you today. Staff and Adam are requesting your approval of this agreement in lieu of a hearing on these issues. Of the agreement are as following. Adam has agreed to liability for 10 commission rule violations, which include the failure to build a berm around a crude oil tank, clean up oil in the well cellar, perform a mechanical integrity test, and demonstrate that E&P waste was properly disposed of. The parties have also negotiated a total penalty of $149,469 for these 10 violations. Prior to executing this agreement, Adam paid the full amount of this penalty. The parties have also agreed on required corrective actions at the Taylor 3 well, which include the violations at issue today, as well as other issues at the site. They also encompass the Dorfer 2 well and Dorfer 1.5 well. Adam has also agreed to the consequences for noncompliance with this agreement, with the agreement's corrective actions, which include staff authorization to suspend Adams Form 10s, terminate Adams Form 1, foreclose on its financial assurance, require Mr. Tom Stover, Adams Oil and Gas Properties Manager, to notify the commission should a company he is affiliated with join or submit a permit or Form 10 request. It allows staff to use state funds at Adam locations if necessary, and claim equipment, saleable product, and appurtenances in the event that state funds are expended. The parties request that the commission approve this agreement, and if the commission approves the agreement, it will be incorporated into the final commission order issued as a result of this hearing. However, this agreement does not resolve all of the issues in this case regarding the second NOAV for the failure to comply with the cease and desist order. The disputed issues before you today are whether the operation of the pumping unit at the Taylor 3 well constituted a violation of the cease and desist order, and whether staff's requested $90,000 penalty is appropriate for this violation. The cease and desist order mandated that Adam immediately cease oil and gas operations at the Taylor 3 well. Cease and desist are two words that unambiguously mean stop. Adam did not stop operations and instead continued to operate the pumping unit at the Taylor 3 well, even after receipt of the order. This is documented by video evidence and is undisputed that it lasted 6 days. These facts are undisputed. Mr. Stover was emailed the cease and desist order on February 23rd. Adam was served with a hard copy of the order on February 28th. Adam operated the pumping unit at the Taylor 3 well from at least March 8th to March 14th. Adam continued to operate the pumping unit for 3 days after staff provided Mr. Stover with video evidence of the noncompliance. Staff will call 2 witnesses on direct today to help provide some context for these facts. First, Director Lepore will testify regarding cease and desist orders generally, as well as the issuance of this cease and desist order. Stephen Lebowski, the Commission's Southern Colorado Inspection Supervisor, will testify regarding his inspections of the Taylor 3 well, including his videos of the pumping unit in operation. Adam has alleged that the cease and desist order was confusing and therefore did not provide reasonable notice of what was required. The operation of a pumping unit clearly meets the definition of oil and gas operations, as it is defined in the Commission rules and the Act. It is defined as including production operations. The definition of production facility in the 100 Series rules includes pumping. Therefore, the operation of the pumping unit at the Taylor 3 well constituted oil and gas operations. If there was any confusion, Adam could have informally requested clarification from staff regarding what the order required. As you'll see from the record and hear from the testimony of Director Lepore and Mr. Lebowski, no such requests were made. Adam could also have formally requested a hearing on the cease and desist order, as the Act provides an opportunity for, but Adam made no such request. Adam has also alleged that this violation is not serious enough to warrant staff's requested penalty. Staff's requested $90,000 penalty is calculated with a daily penalty of $15,000, the statutory maximum daily penalty. It is calculated for 6 days for the time period from March 8th to March 14th, a time period which is undisputed. Daily penalties under commission rules are a function of two things: the class of violation and the impact. The violation of a commission order is a Class 3 violation, the most serious type of violation. The penalty for a violation can also take into account aggravating factors such as recalcitrance. Regarding the impact assessment, here Adam was in violation of 10 rules at the Taylor 3 well, despite numerous staff requests for the performance of corrective actions for almost a year. Based on this and other facts, the director determined that Adam's operations presented a threat of ongoing impacts to public welfare and the environment, and issued the cease and desist order. Then Adam violated that order by continuing to pump 15 days after the delivery of the order. Such disregard for the authority of the cease and desist order affects this commission's ability to protect public welfare and environment in this case and in future cases. Adam's actions also demonstrate recalcitrance deserving of a significant penalty. Not only did Adam violate 10 rules for an extended period of time, but it then violated the cease and desist order and continued to violate that order even after receiving video evidence of the noncompliance. This repeated defiance of commission requirements was considered as an aggravating factor in staff's assessment of the penalty. In summary, staff is requesting an order finding violation that, first, approves the parties' agreement on the undisputed issues, second, finds Adam in violation of the cease and desist order from March 8th to March 14th for the operation of the pumping unit, and imposes a $90,000 penalty for this violation. The cease and desist order's directive to immediately cease oil and gas operations is not difficult to understand, but Adam's refusal to do so is difficult to understand. It cannot be tolerated and must be appropriately penalized. Thank you.
Brent Chicken, Fox Rothschild LLP on behalf of Adam Petroleum. Commissioners, as borne out by the filings and the agreement of the parties, that the matter is really simple and straightforward, and I think there's agreement on that and the two issues that are here. The parties have worked together over the past several weeks in good faith, and they've come to agreement on 13 of 14 violations, alleged violations, the penalties for those amounts, and that those amounts have already been paid. So the two issues that Ms. Beckstead stated are accurately stated, another thing we agree on. And they're stated in our pre-hearing order as well. Whether Adam Petroleum violated the cease and desist order, and if so, what the appropriate penalty for that violation should be. So, you know, first and foremost, I think it bears on the Commission's time to understand that if facts have been settled and issues have been discussed and penalties have been paid, many of which are far less than the maximum, I don't know that we need to go into any of that, and Adam's certainly not going to unless it's forced to. So discussing just the first two issues, the first issue, the question before the Commission, is whether the language of the cease and desist order, which again we agree requires the cessation of all surface operations, contemplates this sole action of Adam Petroleum, which is the operation of the pump jack, and we're going to present evidence that shows that this well is not capable of production. No production occurred during this period of time. That there have been no personnel on the well site, on any of these well sites, since the cease and desist order was issued. and there's been no operations conducted. This is a pump jack operating because the electric power to the well site had been left on by field personnel, and it may be recalcitrance, whatever you want to call it. Mr. Stover, as the operations manager, believed that it wasn't pumping, and it turned out that it was. We're not disputing that at all. So, the issue is whether that is the case. Obviously, yes, pumping is part of oil and gas operations, but pumping implies something being pumped. This well hasn't produced since we took it over in 2012, I believe, and I don't think it's produced for years before that. So it's not something it was absolutely inadvertence. The second issue, we believe, only arises in the case that the commission were to find that that pumping action, the movement up and down of the pump jack, in fact, it violates the cease and desist order, in which case the issue becomes the fine amount. Staff is seeking the imposition of the maximum penalty of $15,000 a day and cites aggravating factors, all of which are directly related to all the items that we've settled, agreed to, and paid. And on top of that, I don't believe that, at least the opening, doesn't discuss another important issue that the rules require, and the rules simply require that the time fit the crime. You have to have proportionality between the threatened or actual harm to public health, safety, and welfare, and the violation, and that has to be combined with an assessment of the degree of the actual adverse impact. There have been 0 adverse impacts from the 6 days of a pump jack bouncing up and down in a non-productive well. Public health, safety, and welfare has not been impacted by this, and there's no other violations that have not been agreed to and stipulated and settled between the parties that could provide that type of harm, certainly the type of harm that warrants the maximum penalty. And Adam is here not because we are arguing that we didn't, that the facts are incorrect. We just believe that the order shouldn't contemplate things like a pump jack bouncing up and down, or a generator being left on, or floodlights being left on. It contemplates things that are going to hurt the environment, hurt the community, hurt public health, safety, and welfare. And so we intend to provide some evidence today. I'm hopeful that we won't use all of our 60 minutes. And with that, we'll end our opening statement and look forward to staff's presentation. Thank you.
We'll join them in looking forward to staff's presentation.
Staff would like to call their first witness, Director Lepore.
Should we swear in any witnesses that might present now or in the near future?
Right now would be great.
Do we want to swear them all in at one time? Or?
That would be great. Most efficient.
Be great.
Okay. Do you want to tell me who they all are?
Oh, sure.
And maybe have them stand up.
Sure. Could I do Lebowski and Matt Lepore?
And for Adam Petroleum, Mr. Tom Stover.
Do you swear or affirm the testimony you're about to give before the commission in this matter is the truth?
Yes. Yes.
Yes. Thank you.
Thank you, Counsel.
Mr. Lepore, could you please state your name and position for the record?
My name is Matt Lepore. I'm the director of the Colorado Oil and Gas Conservation Commission.
And how long have you been the director of the commission?
Became the director in August of 2012.
So first, let's discuss cease and desist orders generally. How many cease and desist orders have you issued since you became director?
I've issued 2, although one of them was by email and not by personal service. And I will tell you about a third circumstance in which a cease and desist order would have been issued had the operator not agreed voluntarily to take the actions required.
And when are cease and desist orders issued?
By statute, a cease and desist order is appropriate when the director or the commission determine that an operator is in violation or believed to be in violation of rules, and the circumstances around that violation constitute an emergency situation.
So turning to the cease and desist order you issued to Adam, which is Joint Exhibit 3 and Bates page 74. Why did you issue the cease and desist order to Adam?
I think there were two drivers for the cease and desist order. The first relates back to a memorandum of understanding, or really a contract that Adam had entered into with the commission, and that related to Adam's acquisition of some wells out of bankruptcy. These were the Red Mesa wells. This was an entire well field of about 80 wells. And Adam was the purchaser, and there's another entity in here, Hoshi, that has a corporate relationship with Adam, but I'm just going to refer to Adam. Adam was the prospective purchaser of those wells out of the bankruptcy. Because the staff knew that there were some environmental issues at those wells, many of those wells needed work on them, they needed MITs and things like that. We had been in close contact with the bankruptcy trustee, and prior to the bankruptcy trustee agreeing to allow Adam to acquire the wells, we entered into this MOU that had conditions around the way in which Adam would begin to operate the field, including addressing those concerns at some of the wells in a very organized and time-sensitive manner. A critical part of the MOU was that Adam would put forward financial assurance in the amount of $360,000. You all know our concerns around having enough financial assurance in case things don't play out the way we expect them to play out. And this was, again, critical to our agreement, as it were, our conditions for having Adam acquire the Red Mesa wells out of bankruptcy. That MOU was entered into in October 9th, I believe, early October, and the financial assurance was to be paid to us by, I think, November 12th. Was the original deadline for them to pay us the financial assurance. The financial assurance payment was a prerequisite to our giving Adam a Form 10 change of operator, which is the certificate they need to legally operate the wells. So no financial assurance, no legal right to operate the wells. And we gave them a little more than a month initially to come up with that $360,000.
Did you also consider violations at the Taylor 3 well as part of the reason for issuing the cease and desist order?
Right, so that was the second. I said there were two issues, the failure to pay the MOU. Now, keep in mind that the cease and desist order does not issue until February 23rd, so there's a time gap here. They didn't make the November 12th deadline to pay the financial assurance. Extended until December 22nd. They didn't make that deadline to pay the financial assurance. Meanwhile, they're operating wells at the other locations in violation of that requirement to pay us the financial assurance. In early February then, while they're still out of compliance with the MOU, still illegally operating the wells, we issue an NOAV for the Taylor well for violations there that date back, for failed inspections and failed corrective actions that date back until March of 2015. So we've got the Taylor well, they've been operating for a year with a series of adverse inspections, violations, including oil spills around the well itself that have not been cleaned up. So what I face now is an operator who has completely ignored their obligation under a contract to pay financial assurance for almost 3 months, is illegally operating wells without a Form 10 during that time period, and now has a separate well, not part of the Red Mesa deal, that continues to operate with multiple violations, including an oil spill. In my mind, that operator should not be conducting business, and that's why the cease and desist was issued.
Did you send the cease and desist order by email to Mr. Stover on February 23rd, 2016?
Yes, I did.
For the record, this is Joint Exhibit 4 and Bates page 81. Did any Adam representative contact you regarding the cease and desist order after you sent this email?
No.
Were you notified of any communication from an Adam representative to Commission staff prior to March 11th, 2016?
No.
Could Adam have requested a hearing on the cease and desist order?
They could have done so pursuant to the statute.
This hearing.
No.
Lastly, let's discuss the penalty for this violation. Why is staff pursuing the maximum penalty for Adam's violation of the cease and desist order?
So to my mind, the cease and desist order is the enforcement tool of absolute last resort that is available to the commission. It's available to me as director without going to you as commission. And the three that I talked about a moment ago that I would like to elaborate on just a bit have all been issued by me. We'd rather not, in every case, I can think of maybe there is an appropriate case, we'd rather not have to call an emergency hearing of the commission. So it is the tool of absolute last resort, and we do not issue them lightly. That's why there have been only 2 or 3 in my roughly 4 years of being director. It has stringent requirements for their issuance. We just don't do it lightly. And we think if we do, our expectation is that we will not be ignored, that the operator understands. If they don't understand anything else, they have to understand that this is the end of the line. This is a cease and desist order. So I think if you ignore that you violate that cease and desist order, I can't think of any other more appropriate place to impose the maximum penalty that is allowed by our statute.
Thank you, Director Lepore. No further questions.
Okay, we have cross-exam. Is that right? Rebuttal?
Correct. Cross-examination.
Cross-exam.
Okay, sure. Good afternoon, Mr. Lepore.
Good afternoon.
Thank you for laying out the distinction in the cease and desist order between its reasons for being issued in terms of the NOAVs on the Taylor well and then the MOU for the Red Mesa wells. I think that's an important distinction. And again, I guess my first question is, so you confirm the MOU doesn't cover the Taylor well, correct?
That is correct.
And can you also confirm that the only failure that Adam experienced under the MOU was the failure to post bonding?
Failure to post the bonding, yes. Conducting operations without a Form 10, also.
Okay. But is it also correct to say that no other action was taken by either party under that MOU?
Well, the violation of the MOU, the non-violation is maybe not the right word, the breach of the MOU was the failure to post the bond.
Okay, thank you. Do you know Adam's reason for not being able to post that bonding?
Lots of anecdotal stories.
Okay, but no reason that the reason why the bond wasn't posted.
I, again, understand that Mr. Stover appeared in our offices with a personal check, was told that that would not be sufficient. We needed certified funds. He said he'd be back the next day. That didn't happen. Why, over the course of 3 months, he couldn't meet a deadline, I cannot tell you exactly.
And what was the amount of the additional bonding in addition to the $60,000 that Adam had already posted under it statewide?
MOU is $360,000.
And was that comprised of the $60,000 statewide existing and 300 additional?
Don't know.
Could we refer to staff exhibit number 1?
Is there a specific
Yeah,
section you'd like me to look at?
Sorry, I apologize. I'll just refer you to page number 3 and ask you if that refreshes your recollection.
Right. So Adam had a $60,000 blanket bond. The additional $300,000 was comprised of $200,000 pursuant to Rule 702 and $100,000 pursuant to Rule 707.
And what is a bond under Rule 702?
702 is discretionary financial assurance for plugging and reclamation, other things like that. 707 is idle well bonding.
Okay. And how many wells did the MOU cover? Let me rephrase that. Did the MOU cover 80 wells?
That sounds approximately correct.
Thank you. You had mentioned that you had been in close contact with the bankruptcy trustee. Are you aware if the MOU was a condition of the bankruptcy trustee to close the bankruptcy transaction, or if it was a condition of Adam?
My recollection was that it was a condition of the bankruptcy trustee, but I entered those negotiations very late in the game to try to get a deal.
And we appreciate that. Thank you. Do you have any information you can share other than your issuance of the cease and desist order on the operation of the Taylor Well pump jack?
We're not quite sure what you mean by information. My information that it was pumping, that there were multiple violations associated that dated back until March, roughly, of 2015, and that among those violations was sort of a continuous oil in and around the well that had not been cleaned up. And at that point, the Taylor Well violated, after the cease and desist was issued, in our view, the continued pumping of the Taylor Well violated the cease and desist order.
I guess maybe I should refine my question. The operation of the pump jack was causing production in the Taylor Well?
I would not phrase it that way. Pumping the well is an oil and gas operation as defined by our statute. And it's not our job to go out and poke around and find out whether there's product coming up the hole as a result of pumping the well.
But you're aware that one of the stipulated facts is that the Taylor Well hasn't been capable of production, correct, since 2013? Let me repeat.
Irrelevant to whether it was an oil and gas operation at that time.
So then let me ask, do you believe the term pumping implies pumping something?
I could make the argument that pumping means the pumping unit is functioning.
So that's a no?
We'll go with no.
Okay, thank you. You had mentioned some prior cease and desist orders that you had issued. You're familiar with how many have been issued in the history of the Commission, correct?
I do not know how many have been issued in the entire history of the Commission.
So, I'm trying to keep this short, but I have a stack here of every cease and desist order ever issued. And would it be fair to say that you're familiar with those or not?
No.
Wow, I really want to, okay. These would be exhibits offered in rebuttal. They're orders of this commission, I think, either via that or judicial notice, I would be able to offer them. Are you aware that there's cease and desist orders for the drilling of an unpermitted well on a land site or a landfill?
I am familiar with that situation. It involves the rancher's exploration.
There's a are you familiar with a cease and desist order that involves a methane seep so that faucet water burns, which I'm sure this commission is super familiar with?
I am familiar with a scenario that of the kind you describe, and not familiar with a cease and desist order issued related to that.
Would you be familiar with a cease and desist order where a party drilled 6 wells with no permit in violation of setbacks from both lease lines and occupied dwellings?
No.
I think I'll stop with that. Last thing I had a question
Just for
about.
clarification, were you offering these?
Commissioner, I'm trying to avoid having to go through the dance for all of these commission orders. I think the commissioners, if they were to, they can take judicial notice of their own, their own orders, certainly. I'm trying not to do that. The purpose is to show that I don't know if this is equivalent to drilling a well on top of a big hunk of styrofoam or drilling 6 wells without permits that all violate every single rule of the commission. So, and you're welcome to take a look at all of those orders. You have them. There's only 10 of them. So those are easy for you to get. I guess the last kind of question I have is, you had mentioned that there was work performed on a well that was subject to the MOU. Is that correct?
I'm sorry, would you re-ask the question?
So we've established that Adam was not approved as the operator of any of the wells under the MOU, correct?
Correct.
And that work, part of the cease and desist order was the issuance of that cease and desist order based on work that Adam had performed at one of those wells.
Subject to the MOU?
Yes, sir.
Yes, I would. The more important issue was the failure to post the bond going ahead with oil and gas operations on wells subject to the MOU.
Are you familiar with any inspection reports issued post the execution of the MOU dealing with any of the MOU wells?
Not in detail.
Are you familiar with a February 6th, 2016 inspection report issued on the Kroger-Ferguson well?
Objection outside the scope of direct and not really relevant to the proceeding today.
Why is it outside the scope? Is challenging whether or not they did work on one of the MOU wells.
So staff is not alleging that there was a violation of the MOU. We're alleging there was a violation of the cease and desist order. The cease and desist order did encompass the Red Mesa and the Taylor 3 well. But the violation that's at issue today is only the operation of the pumping unit at the Taylor 3 well.
Okay.
So, Commissioner, I'm doing this is because there's anecdotal pieces being inserted into yes and no questions that lend prejudice to my client. I just, if you're going to talk about...
You can challenge any anecdotal information that was stated, I think.
I was attempting to. If the objection's been sustained, then I can't do that, and I'll have to try and do that on my direct examination of my client. So, I don't have any further questions now at this time from Mr. Lepore.
Okay.
Rebuttal.
Rebuttal by staff.
Brief redirect.
Redirect.
Sorry. Mr. Lepore, let's discuss the cease and desist orders you have issued. Did any of the operators that were issued the cease and desist order violate the order?
No.
So as far as you're aware, Adam's violation of the cease and desist order issued today is the first violation of a cease and desist order in the Commission's history.
I think it was clear on cross. I didn't look at every cease and desist order in the Commission's history. I can speak with personal knowledge to the 3 and the one that I didn't have to issue. Every time prior to Adam that we have issued a cease and desist order, or that I have said to an operator, you need to stop doing that right now, or I will issue a cease and desist order, they stop doing it right now.
Thank you, Director.
I did have one further question, and Ms. Beckstead's made it clear that we're just dealing with the issue of the 2 issues that were stated. So my question is, without referencing aggravating factors of other violations, what is the harm you identified from the operation of the pumping unit?
Operating in violation of a cease and desist order, operation by an operator who had flouted an MOU, operations that were contaminating the environment around the well, the Taylor well, with oil.
Solely that pumping unit moving up and down, how did it harm public health, safety, and welfare?
Without going to the well to determine whether there was product coming up the well or whether, as you allege, it was just wasting electricity, our assumption is that Adam was conducting oil and gas operations at the Taylor well, a well known to have leaked without proper remediation for more than a year, operated by an operator who flouted the cease and desist order and couldn't meet its obligation under a contract despite a month-long extension of time to do so for more than 3 months.
I just want my question answered. What is the harm to public health, safety, and welfare from the pump jack moving up and down?
Asked and answered.
Leave it as.
No further questions,
The
Commissioner.
potential harm is what you're alluding to, I guess.
No further questions from your Commissioner. We rest.
Okay. Another witness?
Yes. Call our second witness, Stephen Lebowski. Mr. Lebowski, could you please state your name and position for the record?
Stephen Lebowski, Southwest Field Inspection Supervisor for the Oil and Gas Commission.
And how many years of professional experience do you have in the oil and gas industry?
About 23 years of professional experience in the oil and gas industry. About 5 years with the Commission, 3 years of those in the supervisory position.
Is the Taylor 3 well located in the region of the state that you supervise?
Yes.
Would you recognize the Taylor 3 well if you saw it in a video or photograph?
Most definitely, yes.
How many times have you visited the Taylor 3 well?
There's a dozen inspection reports done by myself, which are...
Objection outside the scope of the issues at hand.
Why is that? We're talking about the Taylor 3 well, which is the...
Correct, but the dozen issues before it that the parties have reached agreement on are not germane to the inspection where the pumping unit was operating.
So that's unclear to me. I'll have to get some professional help.
Do you have a response to this?
I do. So my question goes to whether Mr. Lebowski can recognize a video that he took of the Taylor 3 well. How many times he has been at that well goes to his familiarity with the well and whether he can recognize it.
Makes sense to me. How about you, Council?
I'll withdraw my objection. I think he knows which well we're talking about.
Let's discuss your inspections of the well after the cease and desist order was issued on February 23rd, 2016. Why did you inspect the Taylor 3 well after the director issued the cease and desist order?
I was driving south on State Highway 140 to inspect other wells in the Red Mesa field, and the Taylor 3 well is easily seen while driving on the highway. And I noticed that the pumping unit was active, the pump jack was moving up and down, and that Adam had been told to cease all activities.
Did one of these inspections occur on March 8th, 2016?
Yes.
Did you take a video at that inspection?
Yes.
For the record, I'm now playing Joint Exhibit 9. Mr. Lebowski, could you please review this video?
That shows the pumping unit at the Taylor 3 well in operation with a natural gas engine. The casing head valve is open and the production valve is open, and a flow line is that you see going to the right of the video is connected to a tank.
Did you send the inspection report, which is Joint Exhibit 10 at Bates page 106, to an Adam representative?
Yes.
And when did you send that inspection report?
On March 10th, it went through the system, and the operator received an email, and I was also copied on that email.
Did the inspection report link to the video?
Yes.
Representative contact you regarding this inspection?
Not myself.
Did you inspect the Taylor 3 well a few days later?
Yes.
Did you take a video at that inspection?
Yes.
For the record, I am playing Joint Exhibit 11. Is this the video you took at the March 11th inspection?
Yes.
Video shows.
Shows the pumping unit of the Taylor 3 well in active operation being driven by a natural gas engine.
Oh, I did. Number 9. There we go. Joint Exhibit 11. At the March 11th inspection, Mr. Lebowski.
Yes.
And this is a video that also shows
the pumping unit of the Taylor 3 well in active operation with a natural gas engine.
Okay. Thank you, Mr. Lebowski. No further questions at this time.
Let me ask just a stupid question. 2 or 3 or 4 times, Mr. Lebowski's made reference to a natural gas engine. Has some significance I'm not picking up on?
Yeah, the well was gas being produced by the well,
I thought that
not
might
electricity,
indicate-
an electric motor.
Okay, now, am I supposed to do something, Ms. Beckstead?
Sorry, it's my cross.
Oh, cross,
Commissioner,
okay.
Sorry, sorry, Mr. Chairman. Other than what we see on the video, was there any other anything else that you observed with respect to the pump jack or the well bore?
Detailed in the inspection reports, quite a few observations about the site.
I didn't ask about the site. I asked about the pump jack and the well bore.
It's that there was a stuffing box leak, oil accumulation in the below grade cellar. And,
And is it your understanding that those are all subjects that have been resolved between staff and Adam? Thank you. Can you provide us with any information on the effect of the pump jack operation?
seemed to be contributing to the ongoing stuffing box leak and the source of the oil in the cellar.
Okay, but are you in a position to tell us if the well was producing?
Objection calls for expert testimony of the downhole situation of the well, which Adam specifically asked staff not to get into regarding Mr. Lebowski's testimony.
I'm asking for observation, not his opinion. I'm just asking him if he observed the well producing. Sorry.
Are you withdrawing your objection?
Withdrawn.
I've observed with a FLIR camera the well producing natural gas and being vented on the October 29th inspection.
Okay, but I'm asking you specifically about your post cease and desist order, your post cease and desist order inspections. That would be March 8th, 11th, and 14th, correct?
Correct.
Did you observe the well producing on those days?
I believe if there's enough gas coming up from the well to run the natural gas engine, that would be producing. And if to cause a leak of the stuffing box and accumulate in the cellar, that would also equal production. The production valve open and a flow line connected to the tank, in my opinion, equals production.
Okay, but you're also aware that parties have stipulated that the well hasn't produced.
I'm aware of that.
Once in a while, I see this term had produced in saleable quantities. Or
we actually agreed to the removal of that, Chairman, because that was kind of that was a difficult concept because of this particular issue, because wells tend to have gas that may seep up the annulus, and things like that. You can swab a well, you get oil out of it. Is that production quantities, commercial quantities? We didn't know. So Adam agreed to remove that concept from this hearing. Really, Mr. Lebowski, what I'm getting at is specifically talking about the operation of that pump jack, and other than what you've already testified to, is there any other information that this commission couldn't get from other than looking at the video?
In the database, the well is listed as temporarily abandoned to this date. Inspectors expect to see a temporarily abandoned well not capable of production without serious significant work being done first. If the well was not active, I would have considered that well to be shut in. With the production valve open and the pumping unit active, and the best I could tell, and also based on an active leak, that the well was producing.
We don't have any further questions for Mr. Lebowski.
Do you have redirect?
No redirect.
Do you have anything further for your presentation?
No, staff is concluded and direct.
So we'll have the presentation by Adam.
I'm sorry, I didn't hear. I didn't know if you.
It's all yours.
Okay, lucky me. Can you please state your name and address for the commission?
I'm Tom Stover, and I reside in Castle Rock, Colorado.
Can you please tell the commission your association with Adam Petroleum?
I'm a consultant for Adam Petroleum. The title they provided me is Oil and Gas Property Manager.
Can I just get a little bit of your work experience briefly?
I want to be sure everybody can hear council.
Sorry, am I not?
Okay.
I can probably be. I'm kind of a loud person to begin with, so I'll just stop suppressing myself.
Thank
you. Go on, Mr. Stover. Your association with Adam Petroleum, please.
Adam Petroleum was founded or organized in 2011 and engaged by Adam Petroleum in early 2012 for due diligence of acquisitional opportunities in Colorado, Kansas, Nebraska, Wyoming, or New Mexico.
And Adam Petroleum operates the Taylor number 3 T34 well, which we refer to as the Taylor well in these proceedings, correct?
That is correct.
So let's just talk briefly about some matters that were referred to during Mr. Lepore's testimony, and that is the memorandum of understanding and the bankruptcy proceedings and how we got here. Do you believe? Why don't you give us a short history on how and why Adam Petroleum thought the MOU was necessary with the COGCC?
Well, I don't know if Adam believed the MOU was necessary, but I know it was a requirement of the close. A company by the name of Hoshi Energy was going to acquire the oil and gas assets of the previous operator, Red Mesa Holding. Out of a Chapter 7 bankruptcy in the District of Delaware, I believe. There were approximately 70 to 80 wells that Red Mesa Holding had put into bankruptcy. Hoshi Energy engaged Adam Petroleum to consult for them for due diligence on the project itself as it related to the 70 to 80 wells, and also to help with the COGCC requirements.
And were there issues with the COGCC regarding the Red Mesa Holdings MOU wells prior to Adam and Hoshi becoming involved with them?
Yes, there were.
So was the MOU something that Adam and Hoshi were requiring before they would close the bankruptcy deal, or was it something that the trustee required in order to proceed with the sale?
I believe it was a requirement of the COGCC over the bankruptcy, though the bankruptcy supported the MOU, and Adam participated in the negotiation on behalf of Hoshi Energy on that MOU.
If Adam and Hoshi were not able to reach agreement on the MOU, would they have agreed to have closed the bankruptcy transaction?
No.
Thank you. After the execution of the MOU, it's correct that it's undisputed that Adam did not post the bond required under the MOU, correct?
That is correct.
Was the reason that Adam didn't perform this seminal requirement under this agreement with the COGCC?
We already had a surety bond. There was a statewide bond with the state of Colorado for $60,000, which covered up to a minimum of 100 wells. first place that Adam chose to go on behalf of Hoshi and Adam to accomplish that objective was to that insurance broker dealer. It later became quite quickly known that the minute that the surety companies began to start looking into the wells that were in the MOU as part of the bankruptcy, there was early indication that the risk of the well, the length of the wells being shut in, and the downturn in the fourth quarter of the energy sector made it difficult to arrive or to attain that $300,000.
Is it ever Adam's intent not to post that money?
We continued on working to attain any means that we could. It came down to providing face amount value at a premium cost to the surety broker firms for the $300,000 to provide to the COGCC. As a matter of fact, we continued working through January into February until the cease and desist order on February 23rd was issued, and that stopped any and all potential opportunities.
Okay, so let's fast forward a bit to February 23rd. You received email notification that the commission had, or the COGCC had issued the cease and desist order, correct?
That is correct. I received it on the 23rd of February.
And what action did you take when you received it?
I picked up the phone on behalf of Adam, and I called the field personnel and told them to shut down any and all operations.
And I'm sorry to go a little bit out of order here. I just want to back up. Is it true that Adam purchased all of Hoshi Energy's right, title, and interest in those former Red Mesa wells after Hoshi had purchased them from the bankruptcy?
Yes, as a matter of fact, Hoshi acquired that out of the bankruptcy. And during the period of time that we were attempting to get the surety bond, it became clear that we were having some challenges. So Adam approached Hoshi to acquire 100% of all right, title, and interest out of Hoshi, and did so mid to late December.
And I just want to get that in there. So going back to February 23rd, please continue to walk us through. You've gotten the cease and desist order. You've told them to shut down all operations. What was your understanding of shut down all, cease all surface operations?
Well, we didn't go into specifics, but clearly I told them to stop all activity. We at Adam believed that there were three components that we needed to be focused on in the cease and desist order perspective. One, there was to be nobody out there on that well site. The second thing is we were not to be operating out there on the well site. And the third thing that we knew is there could not be any production out there on that well site.
And is it your belief that as of February 23rd, that was the case with respect to the Taylor well?
We did.
Was that actually the case with respect to the pump jack movement on the Taylor well?
Well, we later learned after the fact, after we'd made that call, that we were notified by the COGCC on March the 11th that the pump jack was still lifting. I appreciate the videos that were here today, but the video that was sent to us, the clarity of the video and the shade of the color that was on the video clearly made it appear that the pumping unit that was operating appeared to be painted green. The direction of the photos that they used today was not the photo that Adam received on the link. So I inquired when I got the call on behalf of Adam, are you sure that's Adam's well? Not to insult anyone, but it did not look from the angle of that shot that was our pumping unit, or that it was Adam's pumping unit. Upon hearing that information, I then turned around and called the field personnel a second time.
I'm going to interrupt you for just a second, just so that the commission understands the dates here. please tell us when you're describing when you got that information and you called what dates those happened on as to March 8th or 11th?
Okay. I got a call from the COGCC on March the 11th that the pumping unit was still running. Now, we had given instructions as Adam to the field personnel to shut all operations down on the 23rd of February. When I got that call, I was surprised to receive the call because I had given instructions to shut down all operations. So not only did I question whether it was the Adam well, the Taylor 3 T3-4, but I then, on that very day of March the 11th, picked up the phone and called the field personnel again and said, we gave you clear instructions on the 23rd of February to shut down any and all operations. I've just been contacted by the COGCC that says there's an operational pump jack that's out there. Did you follow directions and shut that well down or shut operations down? Are you aware that that pump is being pumped? And in the particular case, the field personnel responded, yes, we did shut all operations down on the 23rd. I said, well, according to the video I have, there's a pumping jack out there. I suggest you get in your truck. I suggest you get to the field, and I suggest you make sure that pumping unit is not pumping. At night, again, on the same March the 11th, they confirmed that pumping unit was not pumping. So I then felt that we had accomplished the cease and desist order that it was not pumping.
And just to be clear, the Adam Petroleum has since removed any objection to the videos as to whether or not it's the Taylor well, and has since stipulated to the exhibits. Correct?
Yes. They provided two other videos with different angles or different light on a pumping unit, and it did appear that it was the Taylor 3 T3-4, which we confirmed and agreed it was the Taylor well.
And as the operator of the Taylor well, what was the effect of the movement of the pump jack between March 8th and March 11th?
Well, that's a complex answer. First of all, let me start from the perspective that we don't believe that there was any health or safety damage moving up and down. We had problems on the well to begin with for an extended period of time from completion, and time where that particular pump jack was pumping but no oil was being produced. And one of the reasons for that was we had a number of issues downhole that we were struggling with and confronting, one of which was gas locking. We literally couldn't get the gas lock and the pressure balance such that the pump could lift any oil. So even though I was pumping with a pumping unit, we weren't lifting hydrocarbons. And we had the valves open the other side of the wellhead primarily to try to release whatever we could from a pressure perspective on gas locking to try to create the stability of the downhole for the wellbore.
So now just going to your impression of the cease and desist order,
right,
which required the cessation of all surface operations, did it direct you to do other things that were in that you viewed to be in conflict with that directive?
It was a difficult cease and desist order for us to respond or to interpret, I should say it that way. The cease and desist order consisted of two different components embodied within the same cease and desist order. One, the cease and desist order was focusing on MOU type of activities. Because we had not paid the bond, we were not approved as the operator of any of those wells. On the flip side of that, here we are with the Taylor, which had full assurances, which had everything else that was required of the COGCC. Granted, we had some issues, as Mr. Lebowski has testified here today, but none of them were written within the cease and desist order other than cease and desist operation and cease and desist all surface surface operations. However, embedded within that same cease and desist order was a requirement for Adam to approach a well known as the Kroger-Ferguson number 1, it was the Ferguson number 1 F35, which was an MOU well, and we were told to fix a leak. Well, in that particular situation, here sits Adam trying to interpret a cease and desist order and decide whether or not we fix the leak or we don't fix that leak. We're not the operator of that well per the Form 10, but yet we're being asked by the cease and desist order to fix a leak on that well. So we were trying to determine what was the position that we should have gone.
Thank you. Now, let's talk about, in the event this commission were to decide that a violation of the cease and desist order has occurred based upon the pumping of the Taylor well pump jack, or the operation, I should say, of the Taylor well pump jack. Petroleum's understanding with respect to the process and how a penalty should be imposed.
Well, I believe that the penalty needs to fit whether or not Adam created safety, health, public damage. And the pump jack going up and down with non-production, in our opinion, was due to the fact that the field personnel didn't get everything shut off. So we didn't create damage, in our opinion. We didn't create damage downhole in the wellbore. We didn't create damage to the surface. We didn't create public health and welfare damage or even environmental damage. The spill that's been referred to here was a less than 1 barrel of oil due to a part being set on next to the wellhead or next to the well cellar that had dirt on the surface. We didn't have a spill. So from a safety, health, and public welfare perspective, from that, we had a pump jack going, and that's all I can answer. I don't know how to answer what the fine should be.
And then let me ask you a question. You just testified that you had contacted field personnel on March 11th, and they at that time confirmed that the well was no longer operating.
They confirmed that the evening of. They confirmed that to me via telephone call on the night of March the 11th.
And I know you're maybe not the best person to answer this, but do you know why a follow-up inspection of that well and that pump jack was not conducted till March 14th, 2016?
I would have no reason to answer. I would not know that answer. All I know is that they provided pics to me on the morning of the 12th, and that pump jack was not pumping. The Adam Field personnel. So it wasn't pumping on the morning of the 12th for certain. I cannot answer that question other than that.
I have no further questions, Commissioners.
Cross-examination.
Yes, please. Yeah. This one's not better. Good afternoon, Mr. Stover.
Good afternoon.
You testified that you called the field personnel on March 11th, correct?
I did.
And are those field personnel contractors or employees of Adam?
We had 2 employees before the cease and desist. We now have 1, so they were both employees at that time.
Okay, thank you. Are you also aware that the parties have stipulated that the pumping unit was in operation from March 8th to March 14th?
I'm sorry?
The parties have stipulated to the fact that the pumping unit at the Taylor 3 well was in operation from March 8th to March 14th. Isn't that correct?
No, I'm not aware of that stipulation at all. I'm not aware they signed something. Did they? Never mind, I understand I do. So yes, I guess I do know.
And you testified about the operational reason for pumping, and pumping was in the hope that the well would produce. Isn't that correct?
Of course, we would want the well to produce. This well has been sitting in the open since 1985 when it was drilled. And our goal was to turn it into a productive well. And still is post this hearing.
So the reason that Adam was willing to expend the energy and money to keep the pumping unit operational was that the well could have become productive at any moment. Isn't that correct?
No. Because when we shut things down, one of two things happened. We had a number of different scenarios on that pumping unit. If the gas had discontinued producing, there would have been no production. If the gas lock remained, there'd be no production. The simple fact that they didn't turn off all the power, everything else, whether it was a generator or whatever the situation was, I can answer it beyond that point.
Further questions?
I did have one question on redirect, I think. Thank you, Mr. Chairman. That was brought up, and I think the commission should understand this issue. Mr. Lebowski testified to the fact that the pump jack was running a natural gas engine. But as a representative, Adam, who operates the well, can you provide us some information on how the pump jack was operating and what the power for that was?
We've had different powers out there. We've had propane out there trying to run a motor. We've had generator electricity out there trying to run a motor. We've had the natural gas up the backside of the annulus to try to run the motor. Anything to try to create a situation to alleviate the downhole problems that we were having to make that a productive well.
No.
Commissioner Allward.
Thank you, Mr. Chair. All the dates and everything straight, so it's more difficult than I thought it was going to be. Sorry that we're in agreement that the videos we saw accurately depict the state of the Taylor well on those dates, March 8th and March 11th. That's correct?
Correct.
So as far as what was going on, and then there's a third video or picture that, did you provide that as an exhibit? The first one in which you say it's not the Taylor well?
No, I didn't say it wasn't. I questioned whether it was. I received that video from Jeremy Farron at the COGCC as a link. I logged on to whatever link he gave me, and that's how I saw that video.
And it was different than these?
And it was different than those two.
But you didn't provide that link as an exhibit?
No, we stipulated that was the well, and later after the fact we agreed with Jeremy it was the well.
Okay. Do these sorts of engines, I'm trying to figure out what was going on before March 8th also. Do these sorts of engines start on their own?
Well, you can get engines that have timers on them. We went through 3 or 4 different motors out there on this particular pumping unit. Some of them were diesel drivers, some of them were propane drivers, some of them were natural gas, some of them we had generated with a generator out there. But some of them do come with a kill switch or an on and off switch or a timer switch. And so we cannot answer at this point whether or not all that was done.
Because what I'm trying to figure out is you said that no one was on the location once you got the cease and desist order. And I don't recall whether that was, when you did it, whether that was the 23rd or the 28th.
On the 23rd of February, I told them to shut all operations down. And that was the last time through today that we've had any field personnel on that location.
Okay. Thank you. Thank you, Mr. Chair.
Okay.
Could I ask one follow-up question for your response to Commissioner Allward's question?
You may if you can.
Assistant AG?
Yeah.
Okay.
You can
Mr. Stover, you just responded to Mr. Allward's or Commissioner Allward's question about there being no field personnel on the site from February 23rd to March 14th, correct?
That's what they were instructed. No personnel is to be on the site.
But the well was shut off and stopped pumping on March 14th, correct?
Understand? Yes.
So could the well have been shut off remotely?
Potentially. We could have had the electricity from La Plata Electric pulled off, which would have shut down everything.
Okay, thank you, Mr. Stover.
Mm-hmm.
I have no redirect.
Do you have any other witnesses?
I have no further witnesses.
Do you want to have commission questions?
Are there any commissioner questions before they have closing statements?
I believe staff has rebuttal before closing.
Right. Sorry.
No problem.
You guys want to change places?
No, she is happy to be there. Believe me.
Okay.
Okay. Staff would like to call Director Lepore in rebuttal. Director Lepore, Mr. Stover testified regarding the corrective actions in the cease and desist order. What corrective actions did the cease and desist order require?
Would it be okay if I looked at the exhibit to refresh my recollection?
Of course.
Britta, is your microphone on?
It's green, but it hasn't been on the entire time.
Hold it close and speak loudly.
Okay.
You usually do when you're yelling at me.
I'll try. So for the record, this is Joint Exhibit 3. Bates page 77 has some of the corrective actions in the second and third paragraphs. Mr. Lepore, does this help refresh your memory?
It does, and as you can see, Commissioners, at the top of the page is bullet number 6, so the corrective actions start on the prior page, but bullet number 6 is sea, soil, and gas operations. And I suppose the document speaks for itself. Within 7 days, Adam and Hoshi shall clean up the leaking oil from the tank at the Ferguson number 1 F35-1 well and implement repairs and spill prevention on the tank. And then it goes on to say the cease and desist order will remain in effect until such time as Hoshi and Adam have complied with the MOU, obtained required Form 10s, ceased all venting, and are properly managing all E&P waste at the Red Mesa wells and the Taylor well.
Did staff issue the NOAV for a violation of the order because Adam was performing one of those corrective actions?
No.
Did staff issue the NOAV because Adam was not performing those corrective actions?
For violating the cease and desist order, so I guess the answer is yes.
Okay.
I mean, well, if you go back one page to page 3, and the commissioners can read the 6 bulleted items for themselves and the following 2 paragraphs, I mean, it seems pretty clear to me what we were directing, and I would just submit that if Mr. Stover or Adam had questions, they should have picked up the phone and said, we're confused because we don't think we can do both things. I don't think there's any conflict or ambiguity. But we didn't get that phone call.
Thank you, Director Lepore.
Director Lepore, I think we're clear on the COGCC's position that seesaw surface operations means stop everything, correct?
Seesaw surface operations, including including equipment removal at the Red Mesa and Taylor wells, means what it means.
Which is
Stop.
everything.
Stop.
Okay, so on the second page, I mean, really, here's my question. How do you stop and fix at the same time?
I guess you stop everything but what we told you to do, which was go fix it and clean up the spill.
Okay, and that Ferguson well is one of the MOU wells, right?
I believe so, yes.
Okay. So, even though it's not one of the bulleted items, you believe that that means cease 1 through 6 and go fix the leak?
Yes, I do believe that's what it means, and I don't believe that's very hard to wrap your head around.
So is fixing a leak a surface operation?
I could characterize fixing a leak as it was remediation of an environmental impact that you had previously created. Again, if it was unclear.
I understand we could have asked. I'm just asking you if you know, is fixing a leak a surface operation? It's a yes or no question.
No. Not in my opinion.
So, well, without getting into it here, then ceasing surface operations certainly doesn't mean stop all. Is that correct?
If you want me to draw a distinction, I would draw a distinction between producing and cleaning up your mess.
Okay. But we're in agreement that the order says what it says, correct?
Correct.
I have no further questions for Mr. Lepore.
No redirect. Staff would like to call Steve Lebowski in rebuttal. Mr. Lebowski, how many times have you inspected the Taylor 3 well since May 2015?
6.
Was there oil in the well cellar at all of those inspections?
Objection.
What's the basis of your objection?
I thought was we're now going into.
I just want to know.
Yeah, no, I understand. I appreciate that. We're now going into. If you're asking about what the basis of the past inspections were, those inspections, every single item in them has been agreed to by the parties and handled, and it's not relevant to whether or not the pump jack violated the cease and desist or whether the fine is proper.
One of Adam's arguments is that the well was not producing and therefore there was no impact.
That's actually a stipulated fact.
The fact that there was no impact is not stipulated. And
that's correct, I guess.
And to demonstrate that that was not the case, Mr. Lebowski can testify to the oil that was coming out of the wellhead for almost a year, which is, based on his testimony, a potential impact.
All of which goes to the allegations that the commissioners have in their packets with respect to all of the rule violations we heard at the beginning of the meeting. They can read all of that. I think it's unnecessarily cumulative. If he has specific information about what damage the pump jack caused that he observed that is relative to the cease and desist order, we have no objection.
Okay. We can limit our questioning if that helps.
Perfect. That's
It's
perfect.
going to help us a lot.
Okay.
Perfect.
All right.
So the cease and desist order came out on the 28th of February?
23rd.
23rd of February. So anytime after that, if there's oil.
Was there oil in the well cellar at your March 8th, 2016 inspection?
Yes.
Was there oil in the well cellar at your March 11th inspection?
Yes.
Based on your inspections of the Taylor 3 well, was the leak more active when the pumping unit was operating?
Yes, crude oil could be observed leaking from the stuffing box with every stroke of the polish rod.
Thank you. No further questions.
I'd like. That was actually pretty smooth. So. I like that. I just have a simple question: is how much oil are we talking about in the well cellar?
Difficult to get an exact estimation, but it was always about 2/3 full, and I estimate the depth to be 3 or 4 feet.
So would it be fair to say that in some of your inspections you've indicated less than a barrel of oil in the well cellar? Sorry.
I'd have to review the actual inspections of what I estimated on what dates, but they all had photos attached.
Okay. So what I'll ask the commission to do, rather than pulling out all of Mr. Lebowski's inspections and going through them in a very tedious manner, is to please consider that the 3 inspections on March 8th, 11th, and 14th are part of your exhibits. The parties have agreed not to be bringing those exhibits up, and I'm going to honor that agreement, and I'm not going to go handing them to them and asking them about them, but I would ask you to please consider the well cellar issue and the statements of the well cellar issue in those 3 March 8th, March 11th, and March 14th inspection reports that are, and I can say specifically, exhibits. Sorry, you think I know the quicker, but they are exhibits 14, I believe. Greta, feel free to jump in. Because you're smarter than me and you know. 12 and 10. So 10, 12, and 14, I just ask you to. I'm not going to go back on our agreement and sit here and drag all that stuff out. No further questions.
Redirect?
No redirect, only to add to Mr. Chicken's consideration of those inspections. Those inspections do refer prior inspections before March 2016. So you could just view them in that light as well. Thank you.
Commissioner questions?
Commissioner questions, she said.
For her. No, yeah. So then do you want to do your rebuttal? Do you have a rebuttal?
You know, I think I think I'm going to rest. I mean, I could sit here and go over things that we've gone over, but I think between the packets, these things are done heavily on the pre-hearing materials. The commissioners have everything, and I'm asking you to just be critical of the information and the arguments that have been made in our pre-hearing statements and things like that. And I think we're going to rest.
Yep. But you still have a closing statement when
Absolutely, yes, correct. But she gets to go first.
Yeah, just making sure.
you're not going to rest that much.
No, not that much, Chairman. Thank you.
Mr. Chairman,
Hawkins.
I just have one clarifying question. I thought I heard the testimony say that on March 11th, that you made a phone call out to the fields and told them to get in the car and go out there and take a look and make sure that the well was shut in or ceased producing or ceased operations. And then they contacted you back and said it's no longer producing or whatever
Yes,
that your
yes.
words
The morning of the 11th, when I got a call from the COGCC, I contacted once again the Adam field personnel, inquired a second time as to the follow-through of the recommendations on February the 23rd when we received the cease and desist order. I also asked and made sure that they had shut down all operations, was the question. They answered in the affirmative that they had. I said, well, I have a video with a pump jack that's going up and down. I suggest you get out there and confirm that. So they did drive out there, and that evening I got a call back and said the pump jack is not pumping. It's not going up and down. I told them that when they went out there that afternoon that not only did I want to know and hear, I wanted you to take pictures. So on the morning of the 12th, I received pictures showing that there was no pump up and down movement whatsoever. But yes, that happened all on March the 11th.
And then we have a stipulation that the well produced until the 14th. So I'm trying to understand that.
Maybe I can help you with that, Commissioner. By the time we unpacked this, at the time we were trying to facilitate settlement of the matter, and by the time we unpacked it, we realized that we didn't have anybody that could say, yes, it was, or no, it wasn't, between the evening of the 11th and the 14th. All we knew was that it was inspected on the 11th and inspected on the 14th. And we believed at that time that stipulating to that fact made sense, and that's why we are not changing our position on that. We're just asking the Commission to consider that in terms of the per day penalty being imposed, that no party here is, other than the stipulated fact, has actually been out there on the 12th and the 13th to say whether it was or wasn't operating. But we did stipulate to that at the time, and we got to go with what we got to go with.
I guess my concern is if somebody went out there and closed the valves and flipped the off switch, did they do it on the 12th or the 14th?
Correct, and again, we're sitting here dealing with a stipulated fact that we agreed to, but if you asked us to prove that stipulated fact, we couldn't even prove it against ourselves, for lack of a better way to put it. Nobody can prove what was going on the 12th and the 13th at that well, except either us or the Commission staff, which is in part why early on the procedure leading up to this hearing, the parties again got together very early, agreed on a continuance, and I think really self-imposed some pretty aggressive deadlines on each other to get everything together and put together. And I really think that that's what led to 13 of 14 violations being worked through and agreed to. And again, we couldn't prove that fact one way or the other. I don't think the staff could prove that one way or the other. We stipulated to what we stipulated to, and we're just asking that the Commission consider what the testimony today in light of the penalty amount.
All right, thank you.
Commissioner Allred.
Thank you, Mr. Chair. Since my attention was drawn to Joint Exhibit 10, I've been kind of reading through it, and again, both parties have agreed to these exhibits and that they're an accurate reflection of the state of the world at the time.
Yes. Some of them in the pre-hearing order have been agreed to for the specific purpose of responding to questions such as yours, Commissioner, but not necessarily that they're the gospel.
I was just reading through, and now I've just lost my page here. Sorry about that. On the 5th page of that inspection report, the comment says, well, actively producing.
We can't speak to that. That would have to be Mr. Lebowski.
But You agreed to this is just because it was an inspection report, not that it was
We
inaccurate?
agreed to it because in good faith, this is the inspection report, and we stipulated to we stipulated to the exhibit says what it says.
Okay, not that it's
Not
a correct
necessarily
reflection
correct.
of the
Not that
world.
we don't agree with every single thing in every exhibit here. It's just it says what it says, and you pick your battles, and you know the inspection report, to the extent it is the basis of an NOAV. You know, it says what it says. You can challenge things in there, but I'm like, for example, I'm not going to say that it is a fabrication or it's missing a page or something along those lines. I mean, the commission could take it for what it says and ask questions based on that.
Okay, I'm just going to get whether you're not challenging.
Well,
that it's a
obviously,
truthful
the idea was
statement of-
the idea was, and the parties, and I think have mostly stayed to this. Ms. Beckstead and I agreed that we were going to try and make this as streamlined as possible. So, again, it says well actively producing. The parties have stipulated that the well wasn't producing. So there's an inconsistency there as well. And I don't know if that was a colloquial term that when he wrote well producing, he meant the pump jack was operating up and down, maybe. Maybe that's what Mr. Lebowski meant. You'd have to ask him what that meant. But we were nonetheless willing to let the commission look at these documents and take all of it, including the stipulated facts, in conjunction with this and make your decisions. And if there's questions, certainly we can help you with, or that other witnesses called today can help you with. I'm sure we're all happy to do that.
All right. Thank you, Mr.
What
Chair.
was the date? What was the date on that one?
March 11th. Let me confirm that. March 8th. Sorry. Yes.
Okay, Ms. Murphy, we're getting really close to closing statements, and I'm sure they would like to know if they have any time left for closing statements.
Sir, they do. Ms. Beck said you have about 35 minutes left, and Mr. Chicken, you have about 15 minutes left.
Pardon? So would you say that again?
Ms. Beckstead has about 35 minutes, and Mr. Chicken has about 15 minutes.
And they don't have to use it all.
Well, no, sir, they don't.
And I won't need all of it, Chairman.
Okay, Ms. Beckstead, click, tick-tock, tick-tock.
Could sit here for 35 minutes. No, I like to talk too much, so. There's really one question before you today, and that's how seriously should operators take cease and desist orders? Here we have what you could argue is maybe a simple action, but it was also simple to correct it. It was the flipping of an on and off switch. And Mr. Stover has made quite a deal of him telling the field personnel and how it wasn't him personally who didn't shut off the well. But Mr. Stover isn't the one who's the other party to this enforcement action. That's Adam Petroleum. And those field personnel were employees or contractors of Adam Petroleum. There's also been a lot of talk about whether or not the well was producing. That seems to be a big topic of conversation. First of all, based on the definition in the Act and the Commission rules, and as it's used in the cease and desist order, there's no requirement for actual production capable of saleable quantities. And to that point, the stipulation that the parties reached was that the well was incapable of production, and that was in relation to the temporary abandonment status that Adam reported to the Commission as part of its disclosures. That was taken at its face value. The fact of the matter is that oil is coming out of the wellhead. Crude oil, not lubricant or anything else. So the fact that Adam wasn't selling oil shouldn't be part of this equation. What's part of this equation is the fact that Adam disregarded a cease and desist order, even after staff reached out, gave video evidence, And Adam made no requests for clarification from staff. Mr. Stover could have responded to Mr. Lepore's February 23rd email. He could have responded to the inspection report that Mr. Lebowski sent. He could have responded to the March 11th videos with the assertion, "I'm confused." None of those assertions were made. And in fact, today, Mr. Stover testified that he told the field personnel to shut down operations. And he was surprised when the pumping unit was operating. If he had requested shutdown of operations and didn't think that the operation of the pumping unit would qualify, why was he surprised? There's also been talk about the stipulated fact regarding the duration of the violation from March 8th to March 14th. This is a stipulated fact. The parties agreed to this. That is why staff was not prepared to put on evidence regarding it. As Adam admitted, they have no contrary evidence. So our stipulated fact and the fact that we have an inspection, and the only is on March 14th, we know the pumping unit stopped. Adam also alleged that they have photographs of the pumping unit stopping on March 12th, but we have not seen those photographs. Why was a video not taken? A video would probably be more helpful for the active operation. Perhaps most importantly, this commission needs to send a message that violations of cease and desist orders need to be taken seriously. The disregard that Adam had for the cease and desist order, regardless of how allegedly minor, has an amazing impact on this commission's ability to protect public welfare and the environment in future cases. Yes, there is no major, integrity failure in this case, but what if there had been? And there was also oil in the well cellar for an extended period of time that, as Mr. Lebowski testified, was linked to the active operation of the pumping unit. Adam also violated 10 commission rules for an extended period of time, which the parties have reached an agreement on. It then violated the cease and desist order by continuing to operate the pumping unit 15 days after it received the order. And then after Adam received the videos of the non-compliance, it continued to operate the well as far as we know. Staff considered this as recalcitrance. We have not had the reaction from Adam that we would expect of most operators in the state. The director's order to Adam to stop was not complicated. The commission's decision to penalize them appropriately is multifaceted. So in conclusion, staff would like to point you to the proposed order at Bates pages 30 to 38 and the relief requested. The proposed OFE approves staff and Adam's agreement regarding liability for the 10 violations, including the penalty, the corrective actions, and consequences for noncompliance with those corrective actions. It also finds Adam in violation of Section 121 of the Act for the failure to comply with the cease and desist order by operating the pumping unit at the Taylor 3 well from March 8th to March 14th. Lastly, it imposes a $90,000 penalty for this violation, which is appropriate in the light of the gravity of this violation and Adam's recalcitrance at each step leading to this enforcement action. Staff requests that you approve the proposed OFE, Bates pages 30 to 38, subject to any modifications that need to be made to the order based on the events at hearing today. Thank you.
I'll attempt to be brief and touch on what I think the commission should be take from this today. Look, Adam does take this seriously, and I'll direct the commissioners to your packets and the email exchanges between Adam Petroleum and Mr. Stover and Mr. Farron and Mr. Lepore. Throughout this process, they do not evidence a flippance or a disregard. It's absolutely true. Those emails do not sit there and do not ask. Well, what am I supposed to do? That's absolutely true. But they certainly don't. They don't evidence a fact that they don't take it seriously. And quite frankly, if we didn't take it seriously, we would not have worked so hard and expended considerable resources to resolve 13 of these matters in a way that didn't involve a 2-day hearing for this body. The production stipulated fact is from the COGCC's own records. This well has been on temporary abandoned status for 20 years. It's never had a single 3 operators during that period of time, and not one of those operators has been asked to file anything or do anything to maintain that status. That's the status that Adams were at in 2012, and that's what it remains. And the production records are what they are. The commission can take administrative notice of its own records and look and see. That's where we got that from. And so it wasn't a blind faith thing. When you look at the order by the evidence today, it does 2 things. It says stop and fix this. That's the definition of ambiguous. That is it. When you're given a Hobbesian choice, that is ambiguity. That is what happens. The commission the staff has tried to draw a distinction between curative items and things that you're supposed to cease and desist. But I had a professor in law school who told me the simplest law was a stop sign. You didn't have to explain it to anybody. They understand what it means. That should be every lawmaker and administrative body's goal, is to provide that level of guidance. And Adam simply doesn't believe that this order did that. Regardless of that fact, we also do not challenge the great majority of the facts here. Any of the facts that have been adduced today that are not in the stipulated facts are really things that are in support of the party's arguments rather than the facts on the ground. What you see on March 8th, March 11th, the emails, what is in here, those were things that we stipulated to. There was an issue as far as, Adam is surprised that we didn't know the pump, the surprise is not that it was running. The surprise is that we told them to turn it off a month ago and it was still running. That's what the surprise was, not the fact that it was running, or could run, that pump jack could operate. Obviously, we didn't produce photos of a pump jack because that doesn't do much in terms of showing the motion of the pump jack. We'd also ask the commission to take judicial notice of the other cease and desist orders and look at those orders and ask yourselves if the situation before you with Adam is really in the same league as these 10 other orders. Adam submits that it is not anywhere near in this league, and it shouldn't be treated as such. There's been a lot of testimony that has come out about recalcitrance and aggravating factors, but the simple fact is that the key under the commission rules for imposing a penalty is harm. Harm has not been evidenced here at this hearing. You've heard one party say we didn't cause any harm, and the other parties dance around the issue of whether or not there was harm. I asked very straightforward yes or no questions, and they were not answered with yes or no answers. I think you have a hard time offsetting no harm against the maximum fine. Again, we are not saying that this is something you should look the other way and get off scot-free. In fact, we did not submit a proposed order because we agree with the bulk of what is in there. What we disagree with in the staff's order, what we disagree with, what Adam cannot cotton to, is the concept that you have no harm and a maximum penalty is imposed. That will be for the commission's discretion to decide in the first place whether this order provides the guidance necessary, and then secondarily, quite regardless of whether you have to ask, because I understand that you can ask for a hearing to challenge things, but the order itself should provide the guidance necessary. And the only thing that has been evidenced by the harm is speculative.
well, if this happened or if that happened, and I agree that the rule requires the potential for an adverse impact. Adam absolutely agrees with that. But we haven't had any potential impacts, and we haven't had any actual impacts, and there's been no testimony or evidence to that effect. It's been, look at all the stuff that the parties have settled on and use that as the basis to impose the maximum fine. Adam, that's why we're here today, and why we did not settle this matter, because we could not get our heads around. Nobody got hurt by this, not the smallest dormouse, and we're paying the maximum fine, 2 days of which, despite the stipulated fact, nobody's even sure if it was actually running. So, we just asked the commission to listen to all, to take everything you've heard today, take judicial notice of any of your own orders that have come out, and lean less towards the as far as we know and lean more towards the what we know. And I think your packets and the evidence today would lead to the correct outcome in this case. We thank you for your time.
We have some time before we close the record for commissioners to make some inquiries. May I ask Mr. Lebowski, he made a reference to a magic camera he has that indicated there was some methane escaping into the atmosphere. Is that correct, or did I dream?
Yes, it's an infrared camera known as a FLIR camera, forward-looking infrared. FLIR is how the company is known. It's the leader in that technology, and it does create a thermal image which depicts natural gas in the atmosphere.
When was the last time you took a picture of Taylor with this magic camera?
The documented gas being actively vented was October 29th, 2015.
Thank you very much, sir. Any other questions that commissioners might have for Commissioner Hawkins?
I just want to make sure I have this straight. So when the commission issued the cease and desist order on the 23rd of February and then served it by registered agent, served it, was emailed and served on February 28th, so I guess you received it in some kind of mailing. When did you issue a order to the field to cease operations?
On the 23rd when I got it via email.
And then what kind of communications did you have back from the field regarding that cease and desist?
They indicated they'd shut all the operations down. I indicated there's nobody to be out on that well site, and there's no one to be working, operating, anything else of that nature. We didn't get into the specifics of every nut and bolt or every switch or anything else. I expected them to shut all and cease all operations, and certainly we weren't producing, nor have we sold anything off that well. Even for today, there's nothing been sold on that well.
Thank you.
You're welcome.
Okay, we have one other silly question. Temporarily abandoned well can still be active in terms of pump back operating.
By definition, no.
Okay, commissioners, questions. We're going to close the record, and then, of course, you don't get to ask them any more questions. All you can do is ask.
If we're going to ask, I just want to ask, so what is a TA status for them? Is your understanding that a temporarily abandoned status is the status a well is accorded when work is being performed on it to bring it into production?
Temporarily abandoned means the operator has abandoned it for a temporary amount of time, and it's not supposed to have equipment and flow lines connected where it could readily be restarted, that would be considered shut in.
So is there a status that a well would go through? Let me back up. I just want to give you a simple example because this is just so I understand it as well.
He answered your question, and we're not really like open to go back and forth right now because you've already had your time. But if you want to let them continue, you can. I just want to clarify for the record where we are in the proceeding.
Your choice.
I want to hear the answer to that. You want to know?
What I want to know is what happens between temporarily abandoned and a producing well. Is there another status in there that you have to be able to perform work on the well?
You would start reporting production and reporting it as producing, or if you've been doing completion operations, attempted to complete, you would then be reporting it as shut in.
That's fine. If that's okay.
Thank you
No
for
further.
clarifying that point. Other questions? Speak now or forever. Hold your peace, or I guess if it's all right with you, and Chris Murphy will close the record. And deliberate. Is there any benefit to bifurcating this and do the agreement part first, and then the disputed item second? Take it all together.
It's up to you how you want to proceed.
Seems like it may be reasonable to hit that undisputed items and approve the parties' agreement initially, separately, and then. Okay, are there any discussion?
So moved.
Second.
We have a motion and a second. Any further discussion on these undisputed issues portion? They're asking us to approve that agreement. Hearing no discussion, those in favor indicate by saying aye. Aye. Opposed, say
Aye.
Oh, I thank you. Thank you, Deanne. I apologize.
All right.
Any opposed? Same side. Okay, then that agreement stands approved. Thank you. Now,
Thank you, Commissioners.
Disputed items. Is Adam in violation of the cease and desist order? And is the maximum penalty imposed appropriate? For some reason, staff in bright yellow has said we could approve that, subject to any necessary modification as a result of the events at hearing. Tiny window there. They've left open.
Mr. Chairman, that's my fault.
That's your fault.
It is because we adopted staff's proposed order subject to modifications as a result of events at the hearings. Ms. Beckstead used my language perfectly, so.
That makes total sense. I was wondering why Ms. Beckstead would have
That's
given
on
us that kind of wiggle room. Okay, give me some feedback, comments. Commissioner Hawkins.
So can we deliberate now before
Yes,
we
sir.
have any motions? All right.
Absolutely.
You know, just from my perspective, it does appear to me that it was pretty obvious that the Taylor well had not been ceased surface operation. It was continuing to operate. Not sure if anything's being produced and coming out of it, but it was continuing to operate. So I do, under item A, I do at least personally feel that there is a violation of the cease and desist order. However, in item B, I'm a little bit concerned about, and I understand the gravity of violating the cease and desist order. I think that's, as Director Lepore stated, kind of the last resort kind of order that he would issue, and so he expects it to be obeyed. And the concern I've got is that the company was told to cease and desist by their own representative. And so it seems to me that there is maybe some oversight or misunderstanding or something that occurred in the field for that one well to not be shut off. I don't think it was an intentional violation of, we're not going to shut these wells in like you told us to. So I have some understanding of, maybe that the $90,000 penalty could be modified. And I'd be interested to hear how the other commissioners.
Commissioner Hawkins, I'm in total agreement with you. That's exactly where I am. I think the serious implication of a cease and desist order demands that the company that receives it ceases all operation. That's I feel pretty confident that the director and staff would not take that step without having some real major concerns about the possibility of major either environmental damage, human health and welfare, whatever. So I'm consternated relative to lowering that fine because of how important I think it is to expect companies to respond to that order. But I understand what you said. I totally understand. Management told the folks shut it down. For whatever reason, it didn't get shut down. And Mr. Lebowski, I think, has done an exceptionally fine job of demonstrating to us that there was pump jack going up and down. There was some crude oil being produced, and there was some methane coming out of that annulus, I suppose. I don't know what was driving that methane generator. So I'm open to some further deliberations from some of you that are smarter than I.
I don't see the violation of the cease and desist as willful. And so I'm in the same position as you and Commissioner Hawkins, and we're $70,000 over and above any one of the other violations that they've had. So I'm in favor of trying to modify that fine. What that number is, I don't know.
Commissioner Walker.
Well, that makes more logical sense to me, what you're saying. I was going to ask both of you if you really believe that they were in violation of the cease and desist order. I don't understand what your rationale is for lowering the fine.
Well, I hadn't come up with one yet, except that, it seems from what these gentlemen have told us that their intention was to shut it down. They got the order, but, it didn't get done.
So do you believe that the staff did not do their work and their diligence and their follow-through to try to come up with some reasonable approach? And
our staff?
Yeah.
No, I think our staff did a very good job. And I think they're basing their $90,000 penalty on the severity of not following the cease and desist order. And even if it really is the company's responsibility, no matter, they have to see that it gets done. Whether they just tell the field workers do it, but they still are responsible for getting it done. For some reason or another, it didn't get done.
So do you think the fine schedule is incorrect?
No.
Okay.
No, I don't.
I'm pushing you. The last meeting.
Are you an attorney also?
No,
On the side?
I'm struggling with the rationale. I think, as Mayor Holton has said, if you think this was sort of accidental or unintended or whatever, and there should be some sort of moderation of the fee schedule as such that's not otherwise stated, okay.
I mean, I think that's what we're both saying. It appears to me, and I think Tom saw that they told the field to shut the wells in. So I don't think there was any intention for them to continue, shut them all in except for that one. There was an intent to shut them all in, and it sounds like that one, for whatever reason, did not get shut in, but it doesn't appear to be intentional. It's not like they were trying to sneak one by. And when it brought it to their attention on the 11th, they told them again to go shut it in. Go out there and make sure that it's shut off. Except they stipulated that they couldn't prove that it got shut off until this, inspection was made on the 14th. So I'm not saying I'm in agreement with what you're saying. Yeah, we expect all the wells to be shut in. There's a cease and desist order, and that one did not get shut in, so there's a violation. And the question really kind of comes down to how would you penalize that if you view that they were trying to convey that information to the field, and for some reason it was unintentional, but it was overlooked. They didn't get that one well closed in or shut off.
But it's still the boss's responsibility.
Yeah. I'm not saying there shouldn't be a violation. I'm just trying to decide if it should have a modified penalty.
Oh, good. Commissioner Always.
Thank you, Mr. Chair.
Give us some reasonable.
First, I'm going to repeat what some have said, but in different language, because I think the gravity of this situation is severe. When an officer tells me to stop, that means stop. It doesn't, and I cannot use the argument that my continued moving wasn't going to cause any harm, therefore it was okay for me to move. It also does not mean that an officer must conduct an exhaustive examination to determine that there was no threat of my continuing to move before subjecting me to the full force of the law. So the cease and desist is a serious order, and that there needs to be penalties for failure to abide by it. I think we agree we'd have chaos without there being the threat of serious penalties. The other thing is that this $90,000 is basically an agreement that, let's say it was that the pump jack was in motion for 9 days. But there's no evidence provided during this hearing that it had stopped on the 23rd. And so we have somewhere between 6 and 20 days that it could have been operating. And so we're not sitting here, the staff has not claimed to us that they want 20 days or a $200,000 or more penalty. They're saying we've all worked out that it's 9 days. To me, that's a reasonable compromise if the staff is comfortable with that. So I'm or however many, you're right, it was $15,000 a day. So, but somewhere between the agreed upon 6 and up to 20 days, there was a violation of a cease and desist order. So I'm very comfortable with approving the staff's order as it stands.
It's well stated. You said that, in fact, the staff has already made a de facto adjustment.
And I think the parties have agreed that these are things that everybody knows are true, and that it would take a significant additional effort on the part of the staff to document what had happened prior to March 8th, when we've got the video evidence, even though they said that they saw something on March 1st. So I think, yeah, the parties have come to that agreement already.
Any other deliberation, or are you going to make a motion?
The only thing I would point out is that I think the staff has said they can really only document the 6 days that they observe between their inspections, and the other party has not agreed to any of that, as far as I can tell. So I think it just kind of comes down to, in my mind, that it's a very significant order, but I also think they took steps to follow the order to cease and desist. They didn't do a follow-up to make sure that all of those wells got shut in until it was pointed out to them that one was still operating.
Dr. Craig, can you help us through this conundrum?
I'm leaning towards, I agree with Commissioner Allward. If we were in fact talking about a situation in which they purposely did this, we would be talking about much higher fines. And the fines that we're talking about today, they've been adjusted. I know that they're expensive, but those are the new that's the new fine structure that went into effect last year. So I think that's where it needs to be.
Would you like to have the privilege of making a motion?
I move that we that we approve the recommendations as.
Do we have a second to that?
Second.
Okay, any further discussion? Hearing none. Did I hear some?
I was just saying I don't see that there's any need to further discuss this issue. I think we've kind of hashed it out. I understand the rationale for the motion and the second.
Okay, those in favor of the motion indicate by saying aye.
Aye.
Opposed, same sign.
Nay.
One opposition. One. I believe we have the motion carries.
We do. I would note that Commissioner Randall had to leave in the middle of the hearing and did not vote.
And I didn't hear Deanne say aye, but I assume as a motion.
I did say aye.
Thank you very much. Okay, thank you all very much. That concludes this hearing. Or at least that concludes this portion of this hearing. And I believe we're going to continue our hearing tomorrow morning.
Yes, sir, we are.
At 9 a.m.
Yes, sir.
Thank you all very much. Thank you, Deanne.
Thank you.